Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we will ask them, and you will have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left to your oral argument, or if you've asked for less than 2 minutes, it will go on immediately when you start talking. When I call your case, rise, let me know who you are representing and how much time you are requesting. People v. Darrell Rhett, submitted. McNeel v. Broadway Storage. 4 and 2 and 4. K. Feroz is submitted. Pineda v. New York City Health and Hospitals. Five and 2, 4 and 4. State Division of Human Rights v. Metro Wireless. Would you like to submit, or do you want to address the court? You would like to talk to us? Do you want to do oral argument? Okay, we'll give you 3 minutes. Astraa v. Ganley. 5 and 2 and 5. Pena v. City of New York. How much time? 2 minutes.
Respondent.
Oh, he's a respondent. Okay. How about the appellants? 4 and 2 and 2. People v. Antoine Parker. Submitted. Matter of Eugene Woo. We'll go with 4 and 2 and 4. Actually, I'll make it 5 and 2 and 5. 144 Barrow v. Board of Managers. 5 and 2 and 5. Our Children is submitted. ABJ 105 LLC v. Martinez. I think we're okay. If you wish to address us, you may. I'll give you 3 minutes, but we're not asking for you to do that. Oh, very well. Thank you. Submitted. Gomes v. Rue. Is the respondent here? Do you want to address the court?
Yes, please. The respondent is pro se.
No, we know. We'll give you 3 minutes. Hyde v. Oakene. You want time and rebuttal as well? 5 and 5. Century Indemnity v. Office of the New York Attorney General. 5 and 2 and 5. People v. David Shur. 5 and 2 and 5. Halpern v. held in Hines LLP. How much time? Respondents? That's it for respondents? Okay, we'll give you 5 and 2 and 3 and 4. First case up is McNeel v. Broadway Storage. Please.
Thank you, Your Honor. Good afternoon. May it please the court. Payne Tadich for the defendants, appellants, Broadway Storage and 500 Lincoln, doing business as the Gotham Mini Storage. The trial court erred in finding an issue of fact as to constructive notice because the alleged condition wasn't visible to anybody before the accident occurred. The record shows there were 3 witnesses who traversed the area either going through or beside the alleged condition just moments before the accident. This includes plaintiff herself, the defendant's senior property manager, Mr. Goldstein, and the non-party DHL employee.
All three DHL employee, there's some question about whether that person was there, right? The plaintiff questions whether that's the actual person who was present.
Yeah,
The video seems to perhaps contradict some of his testimony.
So he was found by an investigator. He was asked at his deposition, were you there during an accident in February of 2013? He testified, yes, I was. He described the accident. He described a plaintiff who was holding coffee in her hand as she
You're
went
saying
down the
there's an issue of tribal fact, and also putting aside the DHL employee, what about the plaintiff's own testimony? Doesn't that create a tribal issue of fact?
Which part? Because she did say that she didn't see the condition despite walking through
I asked the questions. You have to answer the questions.
No, I don't believe that it does, because she testified that she walked through that exact location. In fact, it's on 243. She says she would have put 1 foot into the condition, but she never saw it before the accident. So she didn't see it. The DHL employee didn't see it. Mr. Goldstein didn't see it, and they all traversed that exact location right before the accident. And the condition we're talking about is this water condition that's actually at the top of the stairs. It's not on the stairs.
So the plaintiff testified that she walked in 20 minutes before the accident,
15 to 20 minutes, correct.
right? So there's that 20-minute period between when she walked in and she said, yeah, I didn't see it when I walked in. And then there's 20 minutes when she fell and said, there's water on my hair, it's on the... So there's at least 20 minutes, right? Where there is no testimony for that 20-minute period as to whether or not the water was there, correct?
That's correct, but let me just clarify one point on that. So she actually doesn't come in through that entrance when she comes in. She doesn't come up the stairs. She came in through the front. So we're not saying that she walked through it at that time. We're talking about in the moments right before her accident. And now she's in this reception area for that 15 to 20 minutes. She never sees it during that time. When she turns to go and proceed down the stairs, and she testified very clearly on 243 that one of her feet would have been right into this water condition. But she never saw it from that time that she was standing in there until the time of her accident. It's only afterwards where she says, I felt it on my hair, and then I turned, and there's the condition. But for constructive notice, the whole test is about visible and apparent before the accident. And this court has...
But she said she wasn't looking. So let's assume that she says, I wasn't looking there. I didn't see it 20 minutes before, but it was there when I fell, right? And what else do you have that shows that you didn't have constructive notice?
Well, I would contest that she says she wasn't looking because she did say she was
We can go back and
looking
forth
at the
about that.
ground.
Let's assume that let's put that aside. What else do you have?
Mr. Goldstein was performing an ongoing maintenance. He's right there in the location.
Does he say anything about that day?
He was testifying about his ongoing inspection that he was doing that day. As he
I
does
look
any-
at it all the time, is what he said. Did he say anything specifically about that day?
He walked down before her.
Again, I'm
On
going to
that day.
ask you.
No, on that day, he walked down before her, right? He was the first one down the stairs. And he said, I did not see any water on the stairs.
Doesn't speak as to maintenance, though.
Right.
Well, the maintenance was when he's standing in that reception area. And you can actually see that in one of the videos that's on the record.
Counsel, don't we usually require on summary judgment motions that there be some record or of regular inspections and that it was actually done on the day in question? Don't we usually require that in summary judgment?
I think if he's actually in this location in a defined area looking, that's more thorough than some sort of schedule or log, which indicates something that was actually done. But here he was
Except he
actually there.
didn't say, I looked at any time that day. He said, generally, I'm always looking. I'm always looking at that area. But he did not specifically say anything about that day.
He did say he was looking down at the steps as he proceeded and walked before her.
And the plaintiff says, it was there because I fell on it, and it was there, right?
Because she felt it in her hair after the
So
accident.
that's, there it is. He says it wasn't there when she fell. She says it was there when she fell.
Not when she fell. She noticed it after she fell based on her hair. And she actually she denied at one point feeling her foot slip. And then she testifies to a condition that wasn't visible and apparent. It was a half a cup of water thinly dispersed on the ground that nobody saw in the moments, despite them all walking through it.
Thank you, counsel. You have time, rebuttal.
May it please the court, good afternoon, your honors. My name is Joseph DePaula from Greenberg Law. I represent the plaintiff respondent, Ms. Kelly McNeel. As the motion court correctly held, and as your honors have pointed out during questioning, quote, defendant's own submission raises credibility issues for the trier of fact to resolve. Despite that holding, we're here today after several enlargement requests for one simple reason. The appellants are seeking to further delay Ms. McNeel from having her day in court.
Well, I mean, they have a video, right?
They do, your honor.
They have a video and they have a couple of witnesses that say there's nothing on the floor. So I don't know that this is, you're acting like this is a frivolous appeal, but they have a video and two witnesses who say there was nothing on the floor before she fell.
And they have, as your honors have pointed out, my client's testimony that directly contradicts it. It is the simple red light, green light issue of fact that we have all known about and learned about on summary judgment motions. And Ms. McNeel is entitled to the benefit of every reasonable inference in opposing this motion. As your honor pointed out, we know there's a 20-minute time frame where there's no testimony about what's on those steps. With respect to the defendant's purported witness, the DHL employee, and I apologize, I'm not going to attempt to say his name, I'll probably butcher it. My client vehemently disputes that he is the person who was there that day, that it was a mistaken person who came to give EBT testimony. That in and of itself raises an issue of fact for the finder of fact. The video itself probably raises more issues of fact than it disposes of. It's taken from a distance. We see clearly that she slips, which also is consistent with her testimony, contrary to the way the appellants are representing it. Her testimony at page 210, my feet just went out from underneath me because apparently there was something slippery under my heels.
Or it could have been, it was snowing that day, right?
It was, Your Honor.
And it could have been the snow on her boots as she was walking down, right? Or
That would be an argument for the jury
Right.
or the finder of fact to determine what caused that, Your Honor. And there is no time frame under which she is required to say, hey, I fell on water, not before and not after. They make a lot of that in their papers and to this court. But again, that's a credibility determination. That's an argument for the jury. That is not for this court. If there are no further questions, I rest on my briefs and I ask the court to affirm the holding below.
Thank you, counsel.
I'm going to read from Mr. Goldstein's testimony, and this goes to the day of the accident. This starts on 401. Question, on the day of the accident, do you recall seeing any accumulation of water located within the area circled in that photograph? Now, he's talking about the photograph that's at 542. This is where plaintiff circled the exact location. Answer, absolutely not. In fact, I was the first one who walked down those stairs, and everything was dry. So that's his testimony about the day of. He specifically was the first one to walk down, and so was the DHL driver was actually the second one. Now, plaintiff claims, and he argued, she vehemently denied that was the person. If you read her affidavit, the basis of it is that they found a website. This is record 588. They found a picture on a website. I don't know what this website is, and she says, that picture on this website is not the person that I saw on that day. There's no indication that this website, whatever website it is, actually pulled a correct photograph of Mr. Dawodu. And we had his testimony where he says, I was there that day and I saw this accident. I walked the steps. I saw nothing on the steps. If they thought that there was any question as to his identity, they could have showed him the video in the deposition. Is that you, sir? Do you remember that? Are you wearing those clothing? They did nothing to that effect. So I don't believe plaintiff claiming, and this was in an affidavit 10 years after the accident, I don't believe that that actually discredits Mr. Dawodu. And the last point I'll make, because I know I'm running out of time, if 3 individuals walk through a condition and nobody sees it, then I believe that it's not visible and apparent. And I don't think 13 years after the fact, we should be impaneling 6 jurors who are going to say the opposite of what the 3 eyewitnesses said about the day of the accident. We don't have a photograph of this condition that they could say, of course, that would have been visible and apparent to someone who was there. All we have is the testimony of the 3 individuals, none of whom saw it despite all walking through it. Thank you, Your Honors, and I'll rest for the rest of my time.
Thank you, counsel. Thank you both. Pineda versus HHC. Please.
Good afternoon, Your Honors. May it please the court. For the plaintiff appellants, this is an action for medical malpractice involving inpatient psychiatric transfer of a patient between 2 hospitals. The defendants are New York City Health and Hospitals Corporation, owning and operating Jacobi, where Mr. Pineda had been admitted. The other defendant is Empress EMS Ambulance Company, which was the ambulance company
We're definitely aware of the facts.
Yes. So
All right, counsel, my question to you, and help me out on this record. Mr. Romano, your expert from Connecticut,
Yes.
who was determining whether Empress emergency medical technicians departed from a standard of care in the transfer of Mr. Pineda from Jacobi to Montefiore. Could you tell me any rule, regulation, or protocol that imposes on the Empress EMTs who were doing a BLS run from Jacobi to Montefiore, that they had the requirement to actually question the patient as to whether he had suicidal ideation, as opposed to relying on the hospital medical providers who determined that he was competent to be transferred without restraints?
If you're asking me to cite a specific rule or regulation section number, statutory or regulatory section number, I can't do that. Per Mr. Romano's opinions, it's part of the EMS standard of care that they're supposed to.
Well, that's my point. Where is that protocol for the standard of care?
Well, the standard of care often is, in medical malpractice cases broadly, is not defined by statute.
But in this case, we do have a statute that determines when a patient gets tied down and transfer, right?
There are statutes, rules, and regulations that govern EMS personnel. Yes, that is true. That does not mean that the EMS standard of care, all standards of care applicable to EMS personnel, are exhaustively set forth in the statutes, rules, and regulations that exist.
Not all standards of care, but with regard to the standard of care in these circumstances, we have regulations that govern that.
That govern what? I don't quite understand.
That govern how a patient is transferred from one hospital to the next. The issue at hand.
There may be some statutes that govern that, yes. Rules, regulations that govern that.
New York Mental Hygiene Law Section 3304 and Department of Mental Hygiene Regulations 526.4, they don't govern, they're not applicable to this case.
I don't think I ever said that they're not applicable to this case. They're not exhaustive.
Oh, so what are the other, where do we get the other elements of the standard of care?
It's from the EMS community, just as,
Oh, okay.
well, I mean, that's how medical standards of care in general, broadly speaking, are defined in large part. It's not statute, rule, or regulation. It's what's accepted in the community.
Can you tell me a case that you cited to that allows you to take the informed consent element and conflate it with medical malpractice? In this case, we know that informed consent runs with the actual hospital or healthcare provider doing the procedure. It doesn't run with Jacobi here because they ultimately didn't do the ECT. So knowing that, what case did you rely on that allows you to take that informed consent element that you want to impose on Jacobi and include it in the general med-mal departure?
I'm not including informed consent in the general med-mal departure.
Well, that's how you answered, that's how you briefed it. You answered it by saying that. In fact, Dr. Singerman seems to suggest that.
No, it's two things that's separated out of an informed consent cause of action. Number one, it's a failure to obtain appropriate clinical documentation, meaning a signed consent form by the patient. Number two, it's a
Yeah, but that would be by Montefiore. Montefiore is the hospital that will be ultimately performing the ECT. It would be their protocol, not Jacobi.
Well, not according to Dr. Singerman's opinions. Dr. Singerman says it was Jacobi's responsibility. And second of all, it's a failure to properly assess his decisional capacity on the part of Jacobi, his ability to even consent. Those are negligent failures that exist separate and apart from an informed consent cause of action. The informed consent cause of action, to the extent that it's applied, creates a no remedy zone in the law, which is an extremely harsh remedy. And it is my view that as such, the restrictions and heightened requirements of the informed consent cause of action should be narrowly applied. And
Thank you, counsel. You have time to rebuttal.
Okay. Thank you, Your Honors.
May it please the court, John Shepwong on behalf of New York City Health and Hospitals. I'd just like to start out by emphasizing that this case is about informed consent, whether you want to call it capacity to consent or whether we obtained written consent. That is all part and parcel of an informed consent claim. I would also add that there's no dispute that Jacobi provided appropriate care, that ECT was appropriate, and that the plaintiff still has a pending claim against H&H with regard to the manner of the transfer in terms of whether restraint should have been applied. So that's still in this case. So this idea that there's no remedy.
Could you just say that last sentence? The plaintiff still has what claim?
The Supreme Court determined that there was an issue of fact with regard to whether restraint should have been ordered by H&H. So that is still within this case. The manner of transfer and whether H&H satisfies its responsibilities, we didn't appeal that. The Supreme Court is still determining that issue of fact. So this notion that there's no remedy here, if this court applies 2805D as written, as Supreme Court did, it just flies in the face of the facts. What 2805D does, it's very specific. It's a limitation on informed consent claims. That's exactly what the legislature called it when it enacted this statute. And what it does is it imposes reasonable guardrails on all informed consent claims, whether it's about capacity, whether it's about whether it was in writing or not, which is not a requirement under the law, I would add. But under that statute, there has to have been an actual procedure performed. There has to have been, and the claim is against the provider that performed that procedure. There was no procedure here.
So the fact that there was no ECT knocks that claim right out.
Disposes of the informed consent claim, and that is full stop, Your Honor. I think that that just disposes of this aspect of the case. Again, there is still the issue with regard to restraints.
Just so that I'm clear, Dr. Singerman did not challenge the actual treatment of Mr. Pineda at Jacobi.
That's absolutely right.
And he did not challenge the medical diagnosis to require ECT.
That's right. So even the decision to transfer Mr. Pineda is not at issue in this case. Dr. Singerman didn't challenge it. It's not an issue in this appeal. All that we're talking about is informed consent, whether you want to call it capacity or in writing, and that is subsumed within 2805D. We have alternative arguments in our brief in terms of the plaintiff's failure to meet the other elements outside of 2805D, but I think that this statute, as written, it really disposes of this case, so I would rest on our brief in terms of those other arguments, unless the court has questions.
Thank you, counsel.
Thank you, Your Honors.
Good afternoon, Your Honors. Brandon Burkowski with Fullerton Beck, representing the Empress Ambulance defendant respondents. The summary judgment motion that Empress made in this case was properly granted by the trial court. We had two competent experts that both opined that there were no departures and that the Empress EMTs did not.
There's no doubt that the statutes and the regulations were followed, correct?
That's what
And
both
so
of
what
our.
counsel seems to be arguing is that the EMT should have asked the person if he was suicidal. And so what do you say about that alleged departure?
Both of Empress's experts opined that EMTs are neither trained nor responsible for conducting a psychiatric assessment in the setting of a hospital.
And I don't think that the plaintiff's expert cited to anything that would support that alleged standard of care, right?
That is
He just
correct.
said it. Normally, when you see an expert will cite to a number of things to support an opinion like that, right? This was none.
That is correct.
And were your two experts, were they from New York?
Yes, they both were from New York.
And was plaintiff's expert a New York EMT person?
He's an EMT in Connecticut.
In Connecticut, right?
And we argued that he was thereby not familiar with the very particular practice environment of New York State and also New York City, which has specific rules governing EMT procedure.
In fact, on debate stamping is strange here, or the numbering on 120 or 10020 of the record. Mr. Romano actually said that it was the Jacobi and not Empress had the authority to order the patient to be restrained physically and or chemically for the transfer.
That's accurate.
Which makes clear to me, I think, that the BLS transfer, the EMTs, your EMTs, had to rely on the Jacobi doctors for that determination. They don't make that independent assessment, correct?
I agree. It's our position that all the parties are in agreement.
And their very experts said that.
Exactly. Yes, it's in the expert affirmation. It's our opinion that all the parties agree that this was not the psych assessment of this patient's mental status at the time of the transfer was not within the scope of the EMT's function to try to assess. As long as they've taken the vitals, which they did, and noted that the patient is cooperative, which he was, documented, there's no reason that they should have needed to investigate any further into the transfer that they were about to conduct.
And in addition, the purported standard of requiring the EMTs to ask the patient whether he is suicidal presumes that they're going to get a truthful answer.
Yes, I mean, our take is that that's the assertion that question should have been asked is entirely speculative. You can't guarantee it's going to be a truthful answer. Moreover, unfortunately, the patient jumped over the retaining wall and was severely injured. But there's not even proof in the record that was a suicide attempt, rather than just a sort of frantic attempt to escape the ambulance.
Mr. Lamar makes a point about the disparity in size between Mr. Lamar and Mr. Pineda, and also that Mr. Lamar tried to grab his shirt on the way out. Are those facts pertinent?
No, I don't believe so. The claim with respect to grabbing the shirt is that created a duty, which we, the trial court dismissed that argument outright, and we would agree with that. If there's no further questions, I will rest on the papers.
Thank you, counsel.
Thank you.
So just a couple things, Your Honor. When I said that there was no remedy, I didn't mean that plaintiff appellant in this case had absolutely no remedy left as to New York City Health and Hospitals Corporation. What I meant was that it creates no remedy. There's no remedy on the issue as to which the lack of informed consent, the lack of informed consent requirements are applied, which are in this case the failure to obtain the signed written consent form, failure to properly
But I
evaluate.
mean, always, you have to have some kind of damage from it. And since the ECT was never done, I mean, that's part of the law, of the claim, right? And you have no claim damage from that.
Well, we do. We have the fall. The fall would never.
From the failure to do the ECT, from the failure to get permission to do the ECT?
Yes.
Okay.
Had they properly assessed the decisional capacity?
Well, that's a different thing.
No, but it's connected.
That is a different claim. And that claim survives, right? That claim is still there.
What claim is?
Claim whether that their assessment, their treatment at the hospital, at the first hospital.
I don't think that the claim is still there. The failure to assess decisional capacity properly, that's not there. The only claim that is left on my reading of the lower court's decision is the failure to restrain him physically or chemically on the
Right. So they did. So that's the claim. That's the claim that's
the claim
right?
that's
Okay.
left. But the other claims are cut out by virtue of the application of the informed consent requirements. Now,
First of all, the parents consented. The hospital records reflect that in the discussions between the family, the patient, and the doctors, that they were all on the same page. What regulation required the Jacobi to get Mr. Pineda's actual written consent for a procedure to be done by Montefiore? I'm missing something here.
so again, I respectfully reiterate that medical standards of care, by and large, are not defined by statute, rule, or regulation.
Or even protocol. Why would a transferring hospital have to get written consent when the procedure has to be done by another hospital and they have to go through that drill? I'm trying to understand that.
Because if there's no consent for the procedure, why is he being transferred in the first place? It doesn't make sense.
Because there was consent. You just don't have it in writing from him on the hospital chart here, and that's what you're holding your hat on. And Dr. Singerman doesn't even say that, really, and he's a Pennsylvania doctor. How is he in a position to opine on what a New York hospital should do in this particular context as a transferring hospital?
He's an expert with decades of psychiatric experience. He's familiar with psychiatric standards of care.
Okay.
Thank you, counsel. Thank you all.
Thank you, Your Honors.
State Division of Human Rights v. Metro Wireless.
Hi, may it please the court. Kimberly Fong for the State Division of Human Rights. The division found the corporate respondent liable for sex discrimination based on substantial evidence because the respondent continually cut the complainant's work hours until they were cut completely.
Metro Wireless didn't even appear at the hearing, right?
Right,
So the evidence is unrebutted.
that's true, yes. Metro Wireless did so under circumstances that evince discrimination temporally and based on disparate treatment. The division awarded back pay with damages, compensatory damages with interest, and then assessed a civil fine and penalty with interest. If there are no questions, I will rely on my brief.
Thank you, counsel.
Thank you.
Astraa, NY v. Ganley. Please.
Good afternoon, Your Honors. May it please the Court, Jack Lockwood for Defendant Appellant. Supreme Court should not have granted the anti-suit injunction. This is extraordinary relief that is not often granted. The plaintiff here failed to establish bad faith, a risk of inconsistent judgments, or an intent to harass.
So let me start out with this. In
the Delaware lawsuit, there is an allegation, I was not properly served, correct?
That's correct, Your Honor.
Okay, and that's part of your fraud claim, right? And if that's part of your fraud claim,
Excuse me, sorry.
what claim is that part of?
I don't think it's part of any claim.
Well, why would you plead it then? You don't plead, I don't plead something unless it's got to be a part of a claim, right?
Your Honor, there's a lot
what-
of background facts in the Delaware complaint. We went through the Delaware.
Again, background facts that you're using to support a claim. That fact has been found against your client here. Why would you plead it in Delaware if you weren't trying to undermine the New York judgment?
I think the only reason it would be pled in Delaware under those circumstances is to give the Delaware court background as to what happened in the New York action. And that
That
was
your
proper.
client wasn't properly served?
But that's incorrect. There was a finding that he was served. So that is an incorrect statement of fact in the complaint in Delaware.
Your Honor, I think I have to double check the exact wording of the complaint in Delaware. It does allege that he wasn't properly served, but I agree, and I don't believe that any of the relief in the Delaware complaint.
Okay, let's start.
requests-
What is your claim? What is your main claim in the Delaware complaint?
It's based on the June 2020 transaction between Schumann, who's
And
a non-party.
describe that. Describe what you think that is.
It's described in the complaint as an agreement to purchase to these two outside investors to purchase the shares that had already been foreclosed by Worth Capital. I believe, and a portion of those shares would go to Mr. Ganley, and a portion of those shares would go to the outside investors.
Just purchase the shares with no other, this.
No, Your Honor. Certainly, it
Well,
was in the
let's talk
context.
about, yes, tell me what the agreement was.
It was in the, well, that was the terms of the agreement.
I'm
that
gonna-
Mr.
I'm
Ganley
gonna-
is seeking to enforce. It was in the context of the federal action against Schumann as a guarantor for the underlying 2017 to 2018 loan agreement.
So what did your client put in for consideration of that agreement?
Well,
So
Your
you're
Honor,
saying
I'm
it
not
was a
here to
contract.
litigate the fraud allegation.
I'm trying to figure out whether or not you are trying to undermine the New York judgment.
Your Honor, I think that you can figure that out by looking at the relief that is requested in the Delaware complaint.
At least
Nowhere in the
15
Delaware
million.
complaint are they trying to overturn the finding of personal jurisdiction. Nowhere in the Delaware complaint are they trying to overturn the default judgment here. Nowhere in the Delaware complaint are they.
But when you're alleging that there was no proper service, what does that allegation go to? Does that not go to the default judgment and undermining that?
I think you have to look at the relief for the purposes of whether a judgment is being attacked collaterally. It's not enough to complain about it or to make commentary about it. That is, in my opinion, superfluous to the
I have to
request.
ask you, what do you think, what relief would you get in Delaware? If you won every one of your claims was, the court found for you, what relief would you get?
The value of the shares that should have been transferred to Mr. Ganley under that agreement, and what would
And he would
not be.
still owe, one second, and he would still owe the entirety of the judgment.
Absolutely, Your Honor. There's nothing in the Delaware complaint that seeks to overturn the judgment. And if he gets all the relief that he's asking for in the Delaware complaint, it will not impair plaintiff's ability to recover on the default judgment.
What remedy is he seeking with respect to the fraud as opposed to the breach of contract claim?
Compensatory damages, Your Honor. He's
Of,
not
of,
seeking.
of only the amount of only the amount of the shares?
It's not specifically pled.
Well, then again, it's unclear to us whether or not he is seeking to undermine the New York judgment. If you're just, you can't just say, I don't know what he's going to get on the fraud claim, whether or not part of that relief would undermine the New York judgment.
Perhaps I misspoke. What I'm saying is I can't give you an exact number of what the amount would be for the breach of the 2020 agreement or the related fraud claims in that. What I can say is it's not a one-to-one on the 2017 to 2018 loan agreement. And it would do not, there's none of the relief there. It's just compensatory damages. So would he have more money to pay the default judgment here? Maybe, but that doesn't mean that you're impairing the ability to recover on the default judgment.
Hold on, counsel, please.
All right, a couple of things are troubling me about this. On 118 the record, which is one of the pages of the Delaware complaint, you actually characterize what happened in New York as a wrongfully obtained judgment. In the transcript of the contempt hearing, your client made it very clear that he believed the loan was fully paid off and that the fraud perpetrated needed to be aired. Keep in mind, on this record, as you said, you're claiming it's a separate transaction, but the June 2020 agreement predates this New York lawsuit. And that would have been an affirmative defense, and your claims here would have been able to have been advanced in New York, but you couldn't get there, correct?
I don't agree with that, Your Honor. I don't think it could have been asserted as an affirmative defense.
Well,
This is a non-party, so you would have had to assert an affirmative defense against a non-party. Schumann is the one who entered into the June 2020
Yeah, but
agreement.
Schumann created Astraa, if I'm pronouncing
He transferred the assignment. We don't know anything else.
I understand, but he claims he
They're
was-
separate
yeah,
entities, Your Honor.
Certainly temporally.
You're-
The complaint in this case was brought in 2021, and the alleged fraud was in June of 2020.
2020.
Certainly. And the Texas action is the first place where these fraud claims were alleged, and those predate the New York action, Your Honors. So this is not brought in response to, oh, we
The
didn't.
point I was making was just that you could have put it in your answer, but you have time to rebuttal. We'll talk about it.
Thank you, Your Honor.
Thank you. Marty, you done? Okay.
May it please the court, Richard Schoenstein for the respondent. A couple other things in the Delaware complaint. The Delaware complaint alleges that my client has been operating in the New York courts and obtained relief by trickery and deceit. The Delaware complaint alleges...
The Delaware's, we agree. The Delaware, the complaint says a lot of inflammatory things. But the question is, would the relief, if relief is granted, first of all, I think you and I would agree, or maybe you don't agree, that an anti-suit injunction is an incredibly rare remedy. You tried it once before, and the court said no. So you tried it a second time, and this time I think the court said yes, and I'm trying to figure out what the difference is. So if Mr. Ganley wins in his Delaware suit, what he gets is shares. The Astraa judgment is still intact. So how is this proper? How is an anti-suit injunction proper?
Well, first of all, the Texas action was much closer temporally to when the New York action was started.
I'm asking, yes, agree.
Okay, so this is trying to flip the result in the New York court.
Flip it in what way? The judgment will stay the judgment. The only thing that could happen in the Delaware action is he gets his shares back, which somehow were sold for $100,000 and then miraculously made it to $4 million in order to pay off the second set of investors, which is very curious, but okay. But all he gets is his shares back and the fact that you lied about this agreement and you didn't get it, right?
But he's seeking money damages. He's saying that my client came to a New York court, got a $16 million judgment by trickery and deceit, and that you in Delaware, Judge, should review the whole thing and do a money damages award that goes the other way.
I don't think that's what he's saying. He's
Instead-
not saying that. He's saying in 2020, we entered into a separate agreement, and that's what I am suing on, the 2020 agreement.
It's not a separate agreement. All of that was pled. All of that was argued on the default judgment.
And in fact, the judge below said that would not, even if I let you put that in,
Right.
that would not negate the loan. So no, it doesn't. That this separate action, the judge below acknowledged that this separate 2020 agreement would not negate the loan.
Right, but it
So I'm not sure why you just don't go to Delaware and argue to the Delaware court.
because this case has been around for 5 years.
Sure.
There's a default judgment.
Sure.
They moved to vacate it, they lost. They
Yes.
appealed that. This is our third appeal on this case. They appealed judgment collection efforts. They are fighting the effort in Delaware. And there's a second reason, Judge, which is there is a choice of form provision in the underlying loan agreements that says all litigation has to be in New York.
And why isn't the Delaware court perfectly capable of reading that forum selection clause and dismissing the case? Why should we in New York exercise judgment over a court, a coordinate state court in Delaware?
Because it is a collateral attack on the judgment. It alleges specifically that the judgment was obtained by trickery and deceit, because this court is entitled to defend its judgment, because it violates the forum provision, and because it's done in obvious bad faith.
I still don't see how a judgment in that case would have any effect on the judgment in this case. It wouldn't undo it. It would do nothing. It might be a set-off if he had more money, but it would not undo the judgment in this case. And how would it undo the judgment in this case?
It's asking the Delaware court, it expressly asked the Delaware court to reconsider the proceedings in New York. It expressly asked the Delaware court to consider that there was no jurisdiction in New York. It was trickery in New York, that my client allegedly didn't give the New York court all the information.
How is asking the Delaware court to enforce a 2020 agreement between the parties? That's what this whole Delaware action is about, a 2020 agreement between the parties. It's pled as a breach of contract. It's pled, yes, there are inflammatory other statements. I'm not denying that, but what I am saying to you is, how is enforcing the 2020 agreement between the party a collateral attack on a judgment on a loan, a 2017 loan?
Because all of those allegations would have been proper defenses to the claims brought in this case, which were defaulted.
Except the court below found that they wouldn't. Even if, her decision, even if he had pled that would not have been a good defense to the loan in the first place. It might have been an offset, but it wasn't a good defense.
She thought it wouldn't have been good enough, is what she thought. I mean, it's not that it wouldn't have been relevant. Of course it would have been relevant, but they defaulted. And they went through a motion to vacate, and they went up on appeal, and now they're off in another, and they lost in Texas on jurisdiction. And now they're off to Delaware, trying to get a different result than what they had in here, that what we've been up to on appeal on 3 times, and they shouldn't be allowed to do it. And it's not an abuse of discretion. Remember, I agree, it's a rare order for that kind of injunction, but it's reviewed on an abuse of discretion standard. And Justice Schechter has had this case for 5 years. She reviewed that Delaware complaint in the light of all of her prior rulings and viewed it as an attack on her jurisdiction and issued that injunction.
You make that point in your brief, counsel. Thank you.
Thank you.
Any other questions? Thank you.
I just want to take issue with my colleague's statement that the Delaware complaint, quote, expressly asks the court to overturn the findings in the New York court. It doesn't. I think
That again, we can't figure out why you would put in those allegations. Just why? What purpose to put in allegations that it was trickery, that the service wasn't good? There's no purpose to those allegations unless they have something to do with the claim, right? You don't say something that's irrelevant in your complaint. Maybe people do. But I'm asking you, why put them in if they're irrelevant?
Your Honor, I think it's just to give the background and full transparency of this case. Sorry, Your Honor.
Your client testified at contempt. It was clear in the question and answering between him and the court that he felt that judgment was wrongly entered against him.
Sure, and he probably continues to feel that way, and he's entitled to, but he respects it.
Of course, and he's using the very same sworn testimony in that court are the very same allegations that he used in the Delaware complaint.
Sorry, excuse me, what was, could you repeat
said
that?
the sworn answers and responses to the court that you've heard from my colleague, that allegations of trickery and deceit, that the whole judgment was wrongfully issued, that et cetera, et cetera. That was all the same sworn testimony were the very same allegations he's advancing in Delaware.
he has said the same thing in every court, Texas, Delaware, this court.
Exactly.
And that's being transparent to the Delaware court, which is why we know that the Delaware court knows about what happened. And now, to the extent that he still disagrees with it, I mean, they didn't disclose the fact that this was a secured transaction.
Why not bring the Delaware action more closely? It was in 2024, right? The filing was actually December of 2024. So why not bring the Delaware action more closely, after the alleged fraud in 2020?
All I know is from the record that the Texas action was dismissed on appeal due to a lack of personal jurisdiction.
The reason I ask that is that there's just been a great deal of collection activity in this particular case, and so it does have the flavor that it's just the latest effort to avoid paying the judgment in New York. So that's part of the
I
background.
don't think that it's fair for this record to infer that this is done to delay, that he's been totally transparent with it. If he gets all the relief he wants in Delaware, it's not going to affect their ability to recover on the default judgment. It will not affect the default judgment as a matter of law. The Delaware courts are competent to listen to all of these arguments and determine all of these arguments on their own. The New York courts should have faith in the Delaware courts to resolve this properly, and as a matter of comedy, should defer to them.
Thank you, counsel. Thank you both.
Thank you, Your Honor.
Pineda v. City of New York. I understand the second cross appellant is here with us, so you'll get 4 and 2 as well. Counsel, did you not hear me at oral? I mean,
it's my first time.
Okay.
So I think I was listening so intently. I didn't hear you.
No harm, no foul. It's okay.
My name's Kevin Brennan. I represent the defendants, third-party plaintiffs, and appellants, New York City Housing Authority and Millbrook. And our appeal is limited to asking
Right.
to modify
Labor law 200 and common law.
200 and the common law, yes.
We know, yeah.
And they're both owners. I understand that the Housing Authority is a fee owner and it's a long-term lease. They hired a contractor, the owners did, to build a building.
And they had no authority over the means and methods of the work.
Yes, and
I knew you were going to say that.
And and you're familiar with the fact that he was pulling a metal dumpster on 4 wheels.
So counsel,
and what
essentially the 200 claim and the common law negligence claim should be dismissed against you, right?
Should be dismissed. Yeah, I agree with that. Yes, that's what we.
Is that the heart of your standing up here?
That's the gist of the appeal. Yes,
And the plaintiff didn't dispute that, right?
Well, no, the plaintiff disputes it. I think the plaintiff. What happened in the order was that it's on page 20 of the record. The judge said that we've established that we lacked authority to control the means and methods. But then she went on and said, however, there's no evidence in the record to establish whether the dumpster, the mini, was inspected. And so she denied the motion to dismiss the 200 and the common law on the dangerous condition of
But
a
the
premise.
plaintiff didn't argue that, right? The plaintiff never argued that.
I'm new to this case, so I don't know what the plaintiff.
I don't think the
argued
plaintiff
before, but
disputed below.
In the plaintiff's brief, the respondent's brief, that he's arguing that the judge was correct to deny the motion on that ground, and that's our argument is that no.
Counsel, I think the issue is really with Proceda, but that being said, my understanding of the record is that the plaintiff does not dispute that the Housing Authority and Millbrook did not control the means and methods of work, and therefore those claims should be dismissed against you.
I think I perceive the first part, but not the second part. But if that's so, we can talk about it on my
Well, I guess
reply.
we'll ask, right? We'll ask.
Okay, thank you.
Good afternoon, Your Honors. Benjamin Rahman,
Bring the mic down a little closer.
I'm sorry. Mejbeen Rahman, and if it pleases the court, arguing on behalf of third-party defendant appellants, the Proceeded Construction Corp defendants. In sum, the lower court erred in denying all branches of appellant's summary judgment motion and erroneously determined that there were questions of fact as to our arguments seeking dismissal of plaintiff's labor law claims under section 240, subsection 1, 241.6, and 200. First and foremost, it's well settled that labor law 241 is not applicable to any and all types of accidents or perils that might be attenuatedly or tangentially related to the effects of gravity, just because gravity is involved.
But here, where we have a contraption that is pretty heavy and is still at not necessarily at an elevated height, the weight and the gravity of placed upon something that is pretty heavy, our case law has held would satisfy a claim under 240 subsection 1. Is that not correct?
Well, Judge, what I would say to that is specifically in, for example, the cases cited directly by plaintiff, each and every one of those cases, there was a ramp or some sort of incline involved. For example, in Davila, there was the one fact that was omitted from plaintiff's papers is that it was a 400-pound type of, it was a 400-pound weight, but there was an incline or a ramp involved. In Runner, it was an 800-pound counterweight specifically to address the forces of gravity. But regardless, the scaffold law and this specific provision of the scaffold law, there has to be an absence or a failure of a specific safety device. And in this case, based on the facts in Freitas, for example, there is no other device besides the mini dumpster that would be appropriate for this.
The issue, first of all, we can agree that it was an unwitnessed accident.
Correct.
And from plaintiff's testimony, it's alleged that something with the dumpster, because it was filled with masonry or heavy stuff, and as he was trying to push it, that something happened where he claimed a mini dumpster fell on his foot. That's a claim, correct? And that would go to whether the wheel or any of the wheels were allegedly defective, which would render the mini dumpster a defective safety device in that context.
But there's no question of fact as to the whether or not the wheel was defective, because the mini dumpsters were rolled specifically to the location. So, all the emphasis on that the wheels would have need to be checked, every time they were moved from one location to another is now, the need for that is obsolete, where they were rolled to the location where
Except, counsel, the plaintiff testified that the wheel was broken.
Your Honor, I would respectfully disagree. In plaintiff's 50H testimony, was well established. He had no idea what had caused.
But then later he said, I read his deposition testimony where he said the wheel was broken. That's what caused my accident.
Well, Judge,
did he not say that?
He said it after the fact.
Okay. You can argue that to a jury, but that is what he said. The wheel was broken.
But he had no difficulty. First of all, plaintiff couldn't identify which cart was the one that allegedly caused his injury. So first,
it was the one that fell on him.
Correct.
That's the one. And so doesn't that create an issue of tribal fact? I know that you have stuff to work with at trial. Mr. Griffin's testimony, for example, is contrary to the plaintiff's, but issue of tribal fact, no?
No, there's no issue of triable fact here as to whether or not the wheels were defective, because first there's testimony that they were inspected before they came into Proceeda's possession, and it would be readily visible whether.
Counsel, I got it. The red light's been on for a while, so you have time in rebuttal.
Okay.
Thank you very much. Counsel, since you have two respondents now, I'm going to give you 3 minutes, not 2.
Thank you, Your Honor.
if you need it.
Yes, Jason Lesnick, or plaintiff respondent. I think this case really boils down to two labor law sections, which are 241 subsection 6 and 240 subsection 1, not so much 200 as the court has pointed out. In terms of the 240 subsection 1,
So can I ask you one question, though? Below, you didn't oppose the plaintiff's motion to dismiss, the NYCHA's motion to dismiss the 200 in common law claims, right?
that's correct, Judge.
So you didn't oppose it below, you're not opposing it now, right?
Yes,
So no one's opposing that part of it.
that's correct.
Okay.
It's primarily 240 subsection 1 and 241 subsection,
Okay.
241 subsection 6.
With regard to the 240 subsection 1 cases where you have something that is weighed heavily, does there have to be a ramp involved for it to be considered a gravity-related accident as per our case law?
There's no case law that I know of that supports that inference that there needs to be a ramp involved. The question is whether or not it's gravity related and whether or not it's a de minimis height differential. And in this case, there's no way to prove the de minimis argument because there's no actual weight of how much concrete was in this mini dumpster, how much it weighed. They had people that went and inspected it after the fact and saw my client after the accident.
How
They
do
didn't
you
weigh it.
deal with what is the employer's argument, the construction company's argument, that there's no evidence that the wheel was broken?
Well, first of all, it's their burden to prove that. And
Oh, and they put in the guy who ran over immediately after the accident. He said, I ran over immediately after the accident. The wheel was not broken, it was doing fine. It could not have been fixed in the 30 seconds between when your client yelled, right? So they did meet that burden.
Sure.
So
So
where
then
did you
there's a
raise an
rebuttable question of fact then in that matter because
How?
my client's testimony that when he goes to push immediately, the wheel locks up and it flips over onto his foot. So that just right there is a question of fact. There's another question of fact as that same gentleman, the foreman who comes over, he says that it was actually right side up when he gets there, when in fact my client testified that no, it fell over on his foot. So there's various questions of fact here. I think the lower court got it right, specifically on those two issues, 241-6.
Well, it would only matter with respect to whether the wheel was broken. It doesn't matter whether it's up or down because it's only the question of whether or not something malfunctioned or something that caused the accident that should have been secured.
As to 241 subsection 6, those two industrial codes, yes, that it only matters as to those codes. Unless there's any other questions I submit on the brief.
Thank you, Counsel. Do you wish to have rebuttal, Counsel? No, thank you. Okay, so that's fine. Thank you.
Specifically, Your Honors, with regard to 241-6, this case has already been decided by this court almost fact for fact. The case is Ruggiero v. Cardella Trucking Company. The citation is 1680 3rd 342, and that's 793 NYS 2nd 337. That was decided by the First Department, that there has been no negative treatment to that case.
But in Ruggiero, was there any question about which cart fell on the plaintiff, as opposed to here, where there is some factual dispute about the identity of the mini dumpster?
It was that the facts are identical. So in Ruggiero, the court found that that plaintiff couldn't establish a connection to which specific mini was involved, the offending mini that was involved in his accident. That is identical in this case as well.
How is that identical? The plaintiff said which one fell on him.
Plaintiff could not identify which cart had fallen on him. In his deposition testimony, what he testified was that it looked similar to the mini dumpsters he was using, but in fact, there was no specific connection or identification of the mini that was involved. That was identical.
Except he said the one that I was using was broken. And that is not true in Ruggiero.
I'm sorry.
It's the plaintiff testified that the wheel was broken. And that was not true in Ruggiero. Right.
The plaintiff, but it was plaintiff who testified that there was no problem with the wheels of any of the minis that he was using, and after the fact, he did not notice any damage to the wheels. He didn't notice anything broken. In Ruggiero, the facts are identical. He also didn't notice any problem with the wheels. He didn't notice any damage after the fact, and also the foreman in both cases testified to the fact that there was no visible damage and they saw nothing. And in this case specifically, the same mini dumpster critically was used all day after plaintiff's accident. So I think the question is settled as to whether or not there was a defective wheel. Otherwise, it would have been taken out of commission. Is the red light mean I'm done?
Thank you, counsel. Thank you all. Matter of Amy Woo.
Hi, good afternoon. Before I start, the white light means 2 minutes left.
You have 2 minutes left, but also you want to give your appearance, Ms. Woo. In other words, I'm Amy Woo. I'm here.
Yeah, sorry, I'll start, yeah. Good afternoon. May it please the court. My name is Amy Woo. I'm representing myself pro se. I am an attorney. I had a corporate law practice ending 18, 19 years ago for 8 years, but I was never a litigator. I'm also the sister of a severely disabled, incapacitated person, Eugene Woo, whose guardianship this appeal is about. And I also was his former guardian for 2 years, initially appointed in New Jersey in 2020, and then transferred to New York in September of 2021.
Ms. Woo, there's a threshold question about whether or not that you stipulated to dismiss the appeal in front of the trial court. Do you want to address that?
Yes, that was an awful experience. We had a motion where they're trying to, a lot of this seems to be about should be about my brother, but it's about this promissory note and mortgage that I have on my brother's apartment. They've been trying to invalidate it for the past 3 years since this litigation started. If you actually looked at the appointing order for the successor guardian, the court asked DSS, Department of Social Security, to try to invalidate that mortgage. I don't understand what the issue is. That mortgage and note was approved.
Also, I asked you about the stipulation.
Oh yeah, so that was with that motion. There was a stipulation, so we had this motion, they had a hearing, and then they said, okay, they had a whole attorneys-only conference, including the guardian, but wouldn't include me, and they said, here's a global settlement, Amy, you have to give up all this stuff. You have to give up your promissory note and mortgage, which again was approved by New Jersey court, so it should be given full faith and credit. And then I had to give up my right to appeal here. And what was my consideration? My consideration is weigh in. My cousin has a petition to be guardian for my brother in September of last year. The family just wants someone as a family member to care for Eugene. He needs that type of care. He is severely disabled. He is suffering in the nursing home, 3 years in limbo because she won't hear my case. My case started in July I submitted this initial May of 2023. She didn't even hear it, refused. I had to go to write a letter to the Office of Court Administration to even get her to make a decision, and then she delayed it again. So there's been a lot of delays on the part of the court.
Question is, did you sign a stipulation?
Yes, I signed it, but I think it's a valid contract because my consideration was to hear Wei-Yin's petition.
Did you make that argument in front of the trial court? Usually that's what's done, of course.
Yes, I understand. I will do that, and if you need me to do that, I'll do that, but is there a possibility my brother, I'm sorry there's been so many delays in getting this appeal in front of you in the first place, but I'm pro se, I'm not a litigator, and the bar is, as it is, and no one's really wanting to zealously advocate for me when, they're gonna be seeing that judge again, right? So it's been very difficult to get this case moving, and I am so grateful for the opportunity to speak to you today, and I think at the bottom line, Article 81 should be about my brother.
1 second, are you saying that the court wouldn't hear the application of your cousin to be?
Yes, it's not in this record, but I wrote a letter to the Office Court Administrator.
Well, it's pending. It's not that it hasn't been
he submitted it in September of last year, right? September 3rd. She would not sign it. Meanwhile, the guardian submits all these motions to try to sell my brother's apartment in San Francisco to invalidate my mortgage. She signs all their motions. Wouldn't sign that motion for my cousin. Eventually, I wrote a letter to the Office of Court Administration. Eventually, she puts it on the calendar for January 27th. But she puts the hearing about the San Francisco apartment sale and the validation of my mortgage first. Then at that hearing, she says, I'm going to adjourn Wei Yin, my cousin's petition, indefinitely, no schedule, unless you sign the settlement agreement. So my consideration was to sign the settlement agreement so that she will hear my cousin's petition. And if you look at, and you have those papers too, if you look at that transcript, it's ridiculous. And they're asking me, are you voluntary? I'm like, if you think coercing me to sign this so that you can hear my cousin's petition is voluntary, sure, but it's not voluntary. I didn't want to sign it, but I understand, if you speak to doctors, you'll understand that my brother needs to be in a better situation. He needs family guardianship. And so it was a matter of, to me, and this as well, appeal, to me, is life and death for my brother. It's been 3 years. He's nonstop getting sick. He's currently also now on sick again, got an infection from cross-contamination of the facility. How much are you going to ask my brother to put up with? He's 47 years old. He wants to go home. He wants rehabilitation. He's not vegetative. He is minimally conscious. He's aware, and if you read the documents of the doctors, the brain injury specialists, my brother is aware, can get better if he gets rehabilitation. And meanwhile, he's been 3 years lying in bed, staring out space, not getting out of bed because of his guardian. And all the family wants is a family guardian to take care of him. Sorry.
Thank you, Ms. Woo. You have time in rebuttal.
Good afternoon, Your Honors. May it please the Court, Adenine Medina on behalf of the respondent, Allied Community Support Services. I will address the motion first, since appellant addressed that.
So I can't quite hear you. If you can put the microphone closer or speak louder.
Is that better?
A little bit.
I will address the motion first.
Let me ask you, what happened to the application to have a new guardian appointed?
So that application is still pending. And
Why?
Well, part of the issue that the trial court had was the pendency of this appeal. The court considered
This
that
appeal has nothing to do with appointing a new guardian.
If-
It's
if-
unclear, it's really unclear to me why anyone would put that off, particularly because the law says that a family member should, in the first instance, be the guardian. So I'm really unclear why this is not being heard.
So a couple of things. First, the pendency of this appeal gave the court pause. The court considered that having this appeal pending.
I don't know why, but okay, let's assume that that's true. I can't figure out
Part of the
why.
relief that Ms. Wu is seeking, I think, is was to be appointed a guardian herself. And apparently now, she'd be okay with her cousin being guardian.
So
That is part of the relief sought in this appeal, I believe, is it not?
So it's two separate issues. So the appeal, the current appeal, deals with the appellant's prior motion back in 2024 to be reinstated as guardian. The motion that's pending before the trial court came about after this appeal was commenced, and the stipulation was entered into just 2 months ago, long after this appeal was perfected.
So I guess that Ms. Wu is arguing, why are you holding me to my stipulation when you're not doing what you've agreed to do as your part of the stipulation? And again, I can't figure out why that's not happening.
So there's no reference in the stipulation as to the decision on the motion that's pending. That's not on appeal. However, what I would say is the trial court, what was discussed at the hearing when the stipulation was signed was the fact that the court wouldn't want to issue a decision on that motion while this appeal was pending because there would be inconsistency.
Right, because a part of this appeal is to have Ms. Wu reinstated as a guardian.
If this court were to reverse the order appealed and reinstate Ms. Wu, then the court would have had another determination appointing a different guardian. So we have two different petitions requesting two different guardians that could potentially resort an inconsistency. That's what the court was trying to avoid. Now, what was addressed in relation to the stipulation, among other things, because there are other proceedings that are pending before the trial court.
You see, this is what I'm struggling with. Yes, we have a so-ordered stipulation that where Ms. Wu agreed to withdraw this appeal. At the same time, in her cover letter to us, she specifically said in her cover letter, I have agreed to withdraw my appeal in order to obtain the trial court's agreement to hear Wai Yin Wang's petition at the earliest available date after the withdrawal of appeal. We're now going to April, and this was all done in January. And that's what I think we're concerned with. On one hand, this could be one of those stuck moments procedurally, and I think you understand what I'm saying. At the same time, all Ms. Wu wants is to be heard on this.
Well, the withdrawal of the appeal hasn't been really adjudicated, right?
Well, the appeal was never withdrawn, essentially. The appellant withdrew the stipulation that, there was a stipulation, I'm sorry, there was a letter filed and then the stipulation was never submitted. So the appeal withdrawal never actually came to fruition. And as a result, in the trial court, when the trial court learned about this issue, a hearing had been scheduled previously. It ended up actually not proceeding initially, and then prior motions that had been pending before the trial court that were attempting to be resolved in the stipulation ended up being decided. So the trial court essentially wanted to have this court weigh in on whether or not it would revert back or reverse the denial of appellant's application to be reappointed as guardian before she heard the pending motion. Now, the court also stated, and if you look at the transcript, we will hold a hearing. I cannot just simply appoint the proposed guardian without a hearing, and the court was ready, willing, and able. And also, interestingly enough, all the parties in the proceeding that's currently pending had stated, in relation to the stipulation, we're not going to object, we're not going to oppose to that application as part of the agreement on the stipulation. So everybody was ready to proceed with the application as to the cousin without objection or opposition. What ended up happening is the appellant decided not to withdraw the appeal, which sort of reverted back on all the issues on the stipulation, resulting in
What was the
further
time frame
proceedings.
between those two things? Between everyone agreeing that they would go forward and then the understanding that the appeal was not withdrawn?
Well, this was all in a matter of days. So the stipulation was signed on, I don't have the exact date in front of me, in January, I believe January 23rd. Within days, we had the issue of the appellant reverting back her decision, or essentially backtracking on her stipulation. And what's interesting, she never made a motion before the trial court to either vacate or withdraw the stipulation. She just simply decided not to abide by the terms, which unraveled a whole host of other issues in the trial court, not really pertinent to the appeal, but it goes to the issue of the stipulation was valid stipulation and should have been honored. I would like to address some of the points on the appeal, if I may. I see my time is up.
I'll give you a minute. Go ahead.
The order appeal should be affirmed. The issue before the trial court was the best interest of the incapacitated person. I will also note that before the trial court, when this particular decision was issued, there was no other application by a relative to be appointed. It was only Ms. Wu's application. The pending application did not come in until long after this decision was issued. The issue before the court at the time was the best interest of the incapacitated person. And if you can see from the record, which we submit, is only the tip of the iceberg, but it's clearly set forth in the record that there were many issues that...
Let's talk about the health issue that keeps the IP in the nursing home. You said that there are some medical issues that require him to be in a nursing home, not at home. Is that correct?
That is correct.
And what is that medical issue?
So the IP is currently on a ventilator. The big issue as it pertains to this appeal is the fact that the appellant continues to interfere with the medical decisions and the medical care being provided at the facility. There's ample representation in the record as to emails going back and forth.
Because she advocates for the IP for different type of treatment, what's inappropriate about that?
Not inappropriate for advocating, but she's interfering. So if you
What are you saying is interfering?
So she
has she told a doctor not to do something, or?
Actually, yes, unfortunately. She has presented to the facility, interfering with the nursing care.
In what way? As opposed to advocating for her brother, where does it cross the line from advocating to interfering?
It's my understanding, and it's not fully fleshed out in the record, that...
Well, I can only talk, that's what, because I read the record, and I'm saying, wow, she's advocating for her brother. I'd like to know what you're saying is interfering.
So she presents to the facility with certainly requesting that the nursing staff wouldn't do certain things or provide the care that was implemented, or orders of the medical provider.
Why shouldn't she do that? If she feels like her brother is not being adequately taken care of, I would do that for my loved one. What is interfering about that?
Well,
they don't want to hear her?
Well, she would have to go through the court, because at this point she's not the guardian, so she would have to go through the court. And she has not been impeded from being part of the discussion. In fact, the problem has been that she has
Again, can you point to me one thing? I'm sorry, I just want to know one thing. How has she specifically interfered as opposed to advocated strongly for her brother with respect to his treatment?
So I'm not sure that there's anything specifically spelled out.
So then why are you making that argument?
Because that has been part of the issue in this case. Is that it has a long history that has been before Judge Perry. Judge Perry has heard over and over again the different issues. There have been multiple applications before Judge Perry with respect to the placement of the incapacitated person, and the judge has had before it all the applications with respect to placement, which involve all these medical evidence that has not made it into the record. But you can see from the record the communications back and forth between.
Counsel, let me help you out here, or not help you out, but I think that there's a section of the record note. Justice Perry, in her decision, refers to an affidavit by Ms. Hawk. Is that where we could find how Ms. Woo's discussions were somehow interfering with the medical care of Eugene?
Well, yes. I mean, that's part of the opposition that was submitted in this particular motion, which was.
But I'm asking about a particular place in the record that is identified by Judge Perry, the Hawk affidavit. Is that the place we should look? It's a very large record, counsel, so it's helpful to us if you can direct us to where we should see things that support your argument.
Well, I think what I would like to point, and I don't have the specific reference in the record number, but there's a lot of emails back and forth in the record documenting the interference. We had the ethics committee of the facility getting involved because Ms. Woo kept coming back into the facility trying to stop procedures or trying to stop treatment that was being provided to the incapacitated person.
Thank you, counsel.
If the court has no further questions, I will rely on my brief.
You want another question?
No, I'm sorry. I didn't mean to go on.
Oh, no, it's okay.
Hi. Okay, sorry. I may talk fast, so I apologize. I am, as mentioned, a corporate lawyer. I know contracts. This is an invalid contract. I didn't get a fair consideration. It was also coerced. So it was signed on January 4th in the court. You read the transcript in that motion, you'll see. They made me.
Why didn't you withdraw the appeal? You signed it. Why didn't you
Right,
withdraw
so then
the
I
appeal?
actually attempt, so, because my lawyer's like, this is the best deal you're gonna get, the judge is never gonna appoint it,
Whatever.
whatever.
You signed
So
it. You're a lawyer. You signed the contract. Why
Right.
didn't you?
I signed it, and then I realized afterwards, why did I sign that? Because my consideration was hearing my cousin's petition at the earliest day convenience. That's required under statute, it's in my motion papers. It's under mental health hygiene. She was supposed to hear my cousin's petition 28 days after she signed it. So she delayed the signing it by 3 months. And then she puts it on the calendar for January 27th. And then she just adjourns it. And she says in that transcript, I'm not going to hear it until your appeal goes through.
Basically, you know that you've signed a contract. A lawyer, you understand what the contract says, and you understand what it means, but you don't obey it. You don't obey your stipulation.
Well,
Is
I
that
basically
it?
rescinded it because listen, I understand. My word is usually good, but not when you coerce me and you place me in a situation where I get no consideration. What did they want from me? They wanted me to give up my right to appeal. They also wanted me to give up a promissory note based on what they claim was surcharges, that they've never given me any evidence that Medicaid is going to charge me surcharges. Nothing, everything is all claims of, and they threatened me about Eugene losing his Medicaid. Like everything there's no specifics on anything. If you actually look at their transcripts on anything, they just say things. And then I, again, felt like this is the only way I will ever get weigh-ins petition heard. And so I realize I'm getting red lines, so I just want to say, so I just think it's unfair, using a procedural thing when the Article 81, it's about my brother's best interest. Who should be his guardian? Even if you don't think it's me, please look at the record. There's not a single thing in the past 3 years that Appellate has done that is in Eugene's best interest. Instead, he's deteriorated. He's on a ventilator because of poor care at the nursing home, not because of his brain injury. Brain injury gets better over time, especially if you get rehabilitation. He gets no rehabilitation in the nursing home. This is the problem. If you look at the doctor's letters, he gets better care at home. He shouldn't have been moved to the transfer to the medical, to the nursing home. That is exactly the number one reason why he failed as a guardian, because that's not the least restrictive alternative and is not medically advisable. It's against medical guidance if he actually bothered to talk to any of my brother's doctors before doing it. And then two, there's no financial need. My brother is under community Medicaid when he moved him into the nursing home. In his move to the nursing home, he was appointed February 3rd. He got the order from the judge on February 9th, and there is no hearing. You look at the order, there's no reference to any hearing. They just did that in some sort of conference, and next thing I know, my brother shipped off to the nursing home. And all these things, and Judge Perry says that she has a lot of history. No, at the actual amount of time that she's actually spent on this case is like nanoseconds. And because she doesn't want to have hearings. All this stuff is that she doesn't want to hearings. If she had a hearing, maybe we wouldn't be here. But your record here, she made a decision on a paper submission. All the evidence is there. Their evidence, if you look through the email chains, don't prove anything they say they do. Instead, actually, it contradicts what they say happens.
Thank you, Ms. Woo. Thank you both.
Okay, thank you.
(144) Barrow versus Board of Managers of 130 Barrow. Please.
Good afternoon, Your Honors. William Geller from Braverman Greenspun PC on behalf of Respondent Appellant Board of Managers of the 130 Barrow Street condominium. This is an 881 case where the petitioner here was building a building next to our condominium.
Oh, we know there were 5 licenses, and then there wasn't a license because he couldn't agree to one, and then the case was brought.
Exactly, and the two issues here today are, one, after those 5 original licenses, which were just for excavation and foundation building, which didn't really impact the upper floors of the building, the license proceeding at issue dealt with substantially more interference. Various unit owners' terraces were shut off, some of the common area.
So you want to quantify what the license fee should be.
Exactly.
Yeah.
We want to quantify what the license fee should be. So
it seemed like the court was skeptical of your appraiser, Mr. Rizk, because he was talking about rental values, and that might be some way to connote diminution of value. I don't know. But were there any affidavits from any of the unit holders that were put in?
There was no specific affidavit saying, I'm a unit owner, this construction, which all of the documents, the construction documents, the site safety plan says has to shut off my terrace. I don't think it's particularly useful or helpful or necessary to say, because I can't use my terrace, my apartment is less valuable.
Well, what did you put in regarding your proof of damages?
We put in the expert report, which identified how this construction adversely impacted the use and enjoyment of and value of these apartments, specifically went through each
Put
apartment.
in the rental value of the apartment.
And they're owner occupied, so
Rental.
that was the question.
So, and the court found that that wasn't a relevant, that wasn't not, and in fact, there was an expert by your adversary that said that this isn't a relevant way to figure out that number.
Well,
so that if the court agreed with that, then there's nothing.
Well, the court's decision wasn't that I disagree with the methodology of the risk report. The court's decision was that
this was 9 times, and based on market rental values that the other side found were not the right view. Right? That's what we all read the decision.
The judge said,
yes, that's what he said. So, if you knock out your expert, what is the judge supposed to look at?
Well, I don't think if the judge said 9 times is too much, and that's a fair decision, I think the judge has to evaluate what the expert said and what, and make a determination, not I'm just throwing it out, but
based on what, though? If he throws out your expert's report, what else did you put in? You didn't put in, as my colleague suggested, you didn't put in any affidavits from your. We use our patio every day. If I had bought, if I
don't
knew,
believe there's
anything like that.
So I don't believe there's any authority saying you have to have a unit owner say the patio I can't use. But
go ahead.
You have to put in something to establish raising the licensing fee, right? Especially if we're not able to rely on what the expert put in because it's not applicable.
What I don't think the court did, the court said, I don't like 9 times as much. It didn't actually analyze the expert report. It just threw up its hand and says, I'm not going to make a change. And I don't think that's appropriate. If it held a hearing as to the appropriateness of the expert report, or if it had some consideration of what the methodology is and why that was inappropriate, that might be an appropriate decision. But here it just said no. And I think the court needs to say more and needs to find more.
You want to talk about attorney's fees?
Yes.
We'll talk about it on rebuttal as well, but go ahead.
So the issue here is the referee held a detailed evidentiary hearing, said we're reducing the attorney's fees. These specific amounts are cut by about 16%. And then the court looked again and said, well, there's duplication, there's time not spent on negotiating, which the referee had specifically pulled out as part of that 15% diminution and said, without any reasoning, without any explanation, I'm going to cut your request by 64%. And because the referee had found, the court did not find that the referee's findings were not supported by the record. They just said, I'm going to do it again, and for unexplained reasons, cut it by 64%. And I think, as before, the court didn't identify any legal reason for its basis, which it is obligated to do. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court. Alexa DePiero for Petitioner Respondent, 144 Barrow Street, LLC. Yes, the trial court permitted 130 Barrow to seek an increase in the license fee should it prove to be insufficient, but it made clear that that application had to be supported by adequate proof. That is exactly what the trial court found was missing here. It explained that 130 Barrow simply just reiterated its same arguments and offered the same evidence it offered during the trial court's initial determination, but it did not.
Mr. Rizk's use of rental value, can't that be some kind of stand-in for diminution of value in the apartment? I mean, I know they're not renters, they're homeowners, but maybe the condo allows for subletting, who knows? But anyway, why isn't that a valid way of giving some quantification to the diminution of value?
I think because here, in an ordinary case, maybe it could, but this wasn't the ordinary case. The trial court wasn't making a license fee determination in a first instance. This was an after-the-fact appraisal. So if there was any evidence of any actual loss of use or decrease in value.
Is there any doubt that there was additional loss of use? Is there any doubt that the rooftop deck could no longer be used and that at least a couple, 2 or 3 apartments were going to lose their patios?
I don't think there's any doubt about that.
It definitely was more of an intrusion on the building than the first 5, right?
I don't know if I necessarily agree with that, Your Honor.
Well,
I think
you tell me what you don't agree with. There was 5, and then there's additional work that would add the non-use of some patios and non-use of the rooftop, correct?
Yes.
And you're saying that wasn't more than what had happened?
The prior agreements involved excavation work, as counsel pointed out, demolition. I think that the tenants in that building would agree that that work was fairly intrusive to them while they were living there. I know that construction protections similar to the protections that were
installed. So you're saying this new one was not more intrusive?
Well, you're saying the question of the value of that intrusion wasn't established, right?
I think that the trial court had before it all the evidence that the respondent put in its initial determination, which was affirmations from its general counsel, its board, its architect, which explained the impact that this latest agreement would have on 130 Barrow. And the trial court found that $2,000 was reasonable. Yes, the trial court considered the prior agreements, but that was not an abuse of discretion. It was relevant information.
But the question is, if there's more intrusion occurring, why wouldn't that $2,000 go up?
Again, I don't think I could see that the intrusion was necessarily more valuable. Construction protections were installed under the prior agreements as well.
Available for use in the terrace? Were they available for use under the first 5 licenses?
I don't know exactly, but here the roof deck was not completely obstructed. About 26% of the roof deck was obstructed. The rest of the roof deck.
To know, right? Because you can't make the argument that there was no increase in damages or the effect to the building if you don't know whether the roof deck was affected in the first 5 licenses.
I think, again, it's not about whether the license could have been, maybe the trial court could have awarded a slightly higher license fee. It's about whether there was an abuse of discretion, and based on the record before the trial court, I don't believe there was any abuse of discretion in awarding the same license fee.
I just want to make sure that I'm clear on what you're saying. You're saying that even if we find that there was substantially more of an obstruction, I don't even think you disputed that below, but okay, that there's a substantial more obstruction in between license 5 and license 6, that it's not an abuse of discretion not to increase the amount of the license fee?
I think the trial court, again, made its
I'm asking you that question. Are you saying, assuming that there was a lot more obstruction in 6 than 5, that it's not an abuse of discretion not to increase the license fee?
I don't believe it is.
Okay.
Was there a finding that there was substantially more of an obstruction based on the new work?
No, there wasn't. The trial court rendered its decision based on what was submitted to the trial court at that time, and made its determination in accord with many thousands of license fees that are awarded commonly in this court. $2,000, we cite several cases in our brief, specifically on page 16, where fees within the range of $2,000 are commonly awarded. And if I could just turn quickly into the attorney's fee issue. The trial court under CPLR 4403 was not required to just affirm the referee's report. The report remains.
But the trial court was required to detail its findings regarding how it came to reducing the attorney's fee, right?
I think the trial court notes in its decision that after reviewing the JHO's decision, which the trial court found did not explain its attorney's fee award, the trial court says that it conducted its own analysis of the record and found.
Not to explain that analysis, right?
It explained that there was vague billing entries, there was block billing, and extensive work billed that was not covered by the JHO's referral order, and therefore the trial court was well within.
And we know what work that was by the trial court's explanation?
We don't know what specific invoices the trial court deducted, but the trial court indicated it conducted its own analysis and reduced the fee accordingly. Unless the panel has any further questions, I see I'm out of time, so the rest of my papers. Thank you.
Your Honors, I think it's important to understand the context of the two orders here. What happened is, when this first came on, there was an order and the hearing on the use on the fees on the license.
Right, that was a February 2022 order.
2022 order, and the parties said, let's use this $2,000 fee that was here before as a placeholder with the right to make a subsequent application. Rather than delaying the work and delaying the hearing to find this number, let's put this here for now, and in the future, we will make this application to determine what is the diminution of value. As Respondent's Counsel said—
Counsel, let me ask you, was there dispute or was there disagreement below that the work that was going to be more obstructing than the prior one?
I think there was no dispute at all about
Did anyone, did the licensee say, or the construction person say, no, it's really going to be the same thing? Did anyone argue that?
I was not at those hearings, so I can't state that. My colleague who was certainly didn't mention it.
And did anyone dispute that this was going to be?
I believe not. This is very clearly, as opposed to working in a hole in the ground, blocking serious use and enjoyment of the people's terraces and the common terrace of the building. So it's very clear it's a specific interference with the building's use that I think is as plain is substantially more diminution of value. And Your Honor said, the question is, how do you compute the value? It's really difficult to say what's the reduction of value of the property you own, but as a stand-in, to use the rental value is an appropriate way to do that. And the court did not.
Why is that an appropriate way to do it if we're not dealing with rentals? We're dealing with ownership.
Well, because the way to determine the value of use and occupancy of a piece of real property over time is the rental value. But if it would have rented for X many dollars with a terrace and that many fewer dollars without a terrace, that's an appropriate, may not be the only way, but it's an appropriate way to say how much value was destroyed in a theoretical way, even though it happens to be owned. So I find that to be, I believe, and the expert said, that's an appropriate way to measure it in this case, in the lack of the subjective value of how much is my own property reduced.
Thank you, counsel. Thank you both. Gomes v. Woo. Please.
Good afternoon, Your Honors. If it please the court, my name is Doug Barracks. I represent the defendant appellant, husband in the divorce action. The lower court committed reversible error when it did not allow the prenuptial agreement into evidence and consider it as—
When was the prenuptial agreement issue raised in the course of this
multiple
action?
times. It was never raised formally. The pleadings were never amended, but it was raised during the trial, and it was admitted into evidence 3 times. Now, we do have the issue here of why should the court consider if it's not in the pleadings? Well, we have the problem there is if the court looks at the pleadings themselves, no ancillary relief was requested.
What about the preliminary conference order? Was it raised there?
It was not, but it wasn't waived either.
And what does the preliminary conference order say about raising issues?
The preliminary conference order says that any issue not preserved in it is waived. Now,
So why isn't this issue waived? Because it was not raised in the order, right?
well, it was not, that part of the order was left blank. But we do have the—
What part of the order was left blank?
The preliminary conference order was one of the older forms. It had the—
Right, it sought information about, quote, premarital, marital, or separation agreements, and that was left blank.
It was left blank,
Right.
correct. So
Right, because no one said anything about that issue in terms of putting something in that space.
that's correct.
Right, so it was not raised.
It should have been pled, but the wife also did request counsel fees. That was also waived. That was not in the preliminary conference.
But we're not talking about counsel fees. We're now talking about the prenuptial agreement and whether that issue was waived by virtue of it not being raised in the preliminary conference order.
A strong argument could be made that it was waived, but a strong argument could be raised that the court should have amended the pleadings after it was admitted into evidence.
Did you move to have the pleadings conform to the proof?
That was not done by trial counsel, no.
Okay.
So then how is this supposed to happen? The court by osmosis is going to say, no one made a motion for it. It was waived, and no one made a motion to unwaive it or make a motion to conform the pleading to the proof. How is this supposed to be considered?
Very easily. A, it was put into evidence not once, but 3 times. But B, there is no prejudice and no surprise.
There's no prejudice
That's
by
correct.
arguing that there's a prenuptial agreement at trial?
Well, it was raised multiple times prior to trial during conferences, and there's surprisingly a case that is exactly on point out of the Second Department, Ross versus Ross, where it was not pled, and it was raised at trial during the first time of about a prenuptial agreement. Now,
Was there a waiver in that case?
the appellate division did not say, but here, there's no express waiver, and
You sign it, isn't there a preliminary conference order that's signed by the parties?
it was signed by the
And
parties.
does it say if you don't raise this, you waive it?
That's what the order
So
said.
then how is that not a waiver?
The same way I assume in the Ross case is that it was not raised in the preliminary conference. Now, we don't have the record on that case, but here, any objection to that was not preserved by the wife. when the wife's counsel failed to object to the prenuptial going into evidence. Now, here we have a true disparity in flexibility of the pleadings. If the prenuptial said, all right, it should be out, that's fine. That is one possibility, certainly a valid possibility. But then it should be also equally binding on the wife, for the preliminary conference order expressly did not include counsel fees. So what I'm asking for is that it should be equal treatment to the parties. Either the pleadings govern or they don't. So here we have the section for the prenuptial agreement that was left blank, but for the counsel fees, they for the financial issues, they had maintenance disputed, child support disputed, custody, equitable distribution, but nothing was said about counsel fees.
Well, wait a minute. What you mean when the referral to the special referee didn't mention attorney's fees?
Yeah, I think it was raised during a conference the same way the prenuptial was done. Actually, the prenuptial was raised in a conference months before.
Well, I mean, the right to counsel fees is statutory in the domestic relations law, is it?
But it was waived in the preliminary conference order. It was not in it, where the preliminary conference order lists the issues at
I don't know
trial.
if you can waive a statutory right. I
waive
guess
that.
you can. You can. Okay. All right. Thank you, counsel. You have time in rebuttal. Ms. Gomes, am I pronouncing your name correctly?
Afternoon, Your Honor.
Ms. Gomes, am I pronouncing your name correctly? Is it Gomes, not Gomez?
1 second, please.
Okay, take your time.
I'm gonna talk. My life has been a nightmare. The judge had made a ruling on this case. The counsel fees was talked in court. This is all about control of my life. I'm asking the court to please put a stop to this and give me my life back. I have a 26-year-old kid that's been suffering since the day his father tried to kill me. He developed schizophrenia because he had nightmares about that. I don't sleep. I have nightmares. I walk on the street looking left and right if my ex-husband is sending anyone to kill me. All I'm asking is to have a life.
Did the distribution between you and your ex-husband occur? Did the monies?
He never, the judge made a ruling, but
He hasn't.
he never paid
He hadn't paid. He hasn't paid anything.
anything. I am in debt. I am in very hard financially debt. I haven't paid my lawyer who worked for almost 7 years, timelessly responding over 3,000 pages, motion after motion.
And the court has ordered that your lawyer get paid, right?
Correct.
And he never paid the
He
distributive
never
award?
paid, and this is all about
And
that.
there's no stay, correct? No stay, right?
No.
The judge didn't order a stay. We didn't order a stay. So at this point, he hasn't complied with the court orders.
At this point, he have not complied with any court order.
Do you have access to the Cap Verde property?
Yes, sir.
Okay.
He have used the court system. He knows how to go through it. I am just asking, please. I didn't bring any of that divorce paper because I don't want to see it. All I'm asking this court today is to end this. Give me my life back. I just want to live my life with no fear. Please, that's it. I don't need to talk more. Thank you.
Thank you, ma'am. There's some water right there if you want it.
May I?
Please.
Thank you. With respect to counsel fees, the record is clear that the husband was deprived of his due process on counsel fees. The trial court said,
Counsel, did your client comply with the distributive award?
as far as I understand, there was an application for a stay on that. One of the issues.
There's no stay. There's clearly no stay. So the question is, did your client, if you're disputing the counsel fees, there's also a distributive award, correct?
That's correct.
Did your client make that distributive award?
I believe there was a motion for a stay. I am not the.
But there's no stay. That's what we've just said.
I don't.
So no, the
Counsel,
answer to the
believe
question
there
is
but
no.
I don't want to say without.
Oh, okay.
Going 100% certain. I am appellate counsel.
So no payments have been made on the belief that there was some sort of stay.
Is
that your answer?
Correct. I believe there was a request to stay because the retirement account was made without a quadro. The only way that could be done is to withdraw it. The husband then has to pay all the taxes and then give the wife a substantial excess through that.
Was that raised below?
Yes.
I don't believe so. Not
Yes,
in
it
the written
was
submission.
in the, not at trial, but in the motion to oppose the referee's report by Elliot Pollard.
But when you actually had the trial on this issue, on these issues, that was not raised at the trial on the relevant issues.
I don't think it's actually normally used to, you don't raise whether a quadro. These are the assets. If there's a retirement account via a pension or an IRA, it's always distributed with a quadro. That does not need to be relitigated. That was done in Majauskas way back in 1984. It's just how it's done. The court made an error by saying, okay, we're just going to lump all these things together and whack it down in half, and completely disregarding the Majauskas formula for any pensions, and using the quadros which evolved out of Majauskas by not ordering that the IRA be divided by a quadro. If that
counsel.
is divided without a quadro.
Thank you. Your time's up.
Thank you.
Thank you. That's oral argument then. Thank you. Hyde v. Oakene.
Good afternoon. David Bolton. I represent the appellants Phyllis Weitzman and Bow Faith Company, LLC. If I could, during the argument, I'd like to focus on 4 points. What happened here is there was one discrete transaction between Phyllis Weitzman and Mr. Boise, who's...
Yeah, Justice Hagler found that hard to parse, though. That he found it difficult to bifurcate the MassPeth transaction from the non-MassPeth transactions. Was that incorrect?
Well, no, he found it hard to parse, but we believe and submit that he should have been able to parse those, because we're really having one transaction, and the plaintiff comes in and paints with a very broad brush and says, well, since you were involved, you met this man twice.
Yeah, but the first time was a very important time, because that's when the power of attorney was signed, and she was a witness to that, correct?
I believe that's when she signed a healthcare proxy, not the power of attorney.
Okay.
She did not sign the power of attorney. That was years before.
I see.
Yeah, just a healthcare proxy. And her meeting there was a matter of seconds. She went in and witnessed a signature.
Well, counsel, aren't there a number of funds running in between a number of different bank accounts from withdrawals and deposits that make it hard to parse where the money has been going?
With respect to Mr. Oakley, possibly, but with respect to Ms. Weitzman, it's very clear where the money went from. The money went from Mr. Oakley's account that he apparently was holding for the benefit of Mr. Boise, and went to Ms. Weitzman, and some of that money then went back to Mr. Oakley.
But not all of the money.
No, not all of the money. And
Right, so Ms. Weitzman kept some of that money, or it's somewhere in a bank account. I don't know where it is, right?
I wouldn't say kept, because they had a written agreement that said what it said about whether that money was forfeit or should have been repaid, but she repaid it anyway.
But she didn't repay all of the money.
She wasn't obligated to, but...
And why wasn't she?
Because under the agreement, it didn't...
And what was this agreement for?
A partnership agreement that they were going to look...
For a property that he never lived in? That agreement?
He never lived in it for 2 reasons. One,
It doesn't matter the reason. So you're telling me that there was an agreement where all of this money was transferred, and he doesn't get back all of the money back for purchase of a property that he never had any benefit for.
He had a benefit under the agreement. He didn't avail himself of that benefit. But I agree with the court, and I understand, if this case was about that transaction, and the amount of money that's left, that would be one thing. And it's about $65,000, $68,000 that didn't go back. If that's what this case was about, we wouldn't be here. But this case is about the claim that because Ms. Weitzman was involved in this transaction.
So it's unclear to me, counsel, if it was between her and the incapacitated person or the why she would pay her ex-husband the money back and not him.
That's where it came from. The check came from the ex-husband to her, so she gave it back to the ex-husband.
But your whole argument here is that she had an agreement with the IP. Why would she pay her ex-husband if she had the agreement with her? So obviously it raises more questions than it answers.
Understood. He wasn't incapacitated. There's a serious issue as to whether he was, at all impaired at the time these events.
Well, okay, so I'll say at least there's evidence in the record that at the time he was seriously impaired.
Which is a fair point. And I'd go back to the statement, they're not just challenging this transaction, and that
No, I
number's
agree, but we're talking about your client, right?
Yes.
And so your client says, I entered into a joint venture with him. What did she put into the joint venture?
She put money and time.
How much?
Well, she took a mortgage.
I'm asking you, how much money did she put in?
I don't have that exact number. I think
Put in no cash
no,
of
she
her
put about
own.
26,000-ish. I don't have that number, but she also took a mortgage.
Right.
When she purchased the property, which actually happened after he withdrew. But she did put,
Exactly, so that has nothing to do with him.
well, she put the balance in to make the down payment. So yes, she put in.
She put his money in. That's terrible.
He put his money in,
Right?
and then she put some of her money
Was she able to show that she put in her own money?
Yes, that's in the record, because the differential in amount came from her. So she definitely.
No. That's your argument, right? Was she able to show that?
Well, it had to be because the numbers only work with the amount he put in.
Again, was she able to put up some checks?
Yes. Well, there's a dollar amount that when
There's proof in the record about this dollar amount and where that money came from, and that it came from her account or an account connected to her.
I don't remember if it's a check, but
I don't think there is.
he withdrew before the closing, and her money went at the closing. So to answer the question, it wouldn't flow like that because he withdrew before. I see the time's up, but my point is they're trying to take this transaction, which we would be happy if they wanted to litigate this transaction, but they don't. They now say, oh, she engaged in an undue influence, and she's responsible for all of his money. And we think that's too far a stretch because they had this one single transaction.
So then you'll go to trial, and the jury would determine that, right?
Well, that's an issue. This is really an unwieldy complaint. They have 8 causes of action. Some are equitable, some are legal, and we really think, if nothing else, the complaint needs to be parsed down because it's overbroad. They have unjust enrichment claims when they have a breach of contract claim. They have quasi-contract
Aiding and abetting
claims.
fraud.
I'm sorry?
Aiding and abetting fraud. That's what you're worried about, I take it.
Well, I wouldn't
Or
say
you
we're
think
worried.
it's unjust.
Yeah, well, definitely the aiding and abetting fraud is a problem because there's no evidence at all that she provided, first of all, that she had knowledge or provided substantial assistance with respect to the fraud alleged.
Thank you, counsel. I've given you a little extra time, and you did not ask for any rebuttal, so that's pretty much it. Thank you.
Thank you.
May it please the court, Emma Freeman for plaintiff respondent Maurice Hyde. The standard of review on appeal all but resolves the question before this court. The only question that the court needs to answer here is whether the motion court abused its discretion in finding that across all of the claims at issue, there were multiple questions of material fact.
So other than the Maspeth transaction, what factual dispute do you think there is with respect to the other causes of action? How did you raise a factual dispute?
With respect to the non-fraud causes of action, Your Honor?
With respect to the Maspeth property?
The Maspeth property.
Certainly, Your Honor. So cause of action 6 is actual fraud against Ms. Weitzman. And
Is that has to do with the Maspeth?
With Maspeth.
I'm talking non-Maspeth.
You're talking about
because
non-
that's what counsel's arguing, that you have gone way too far. That Maspeth, sure, but you're not just arguing that there was aiding and abetting fraud with respect to Maspeth, correct?
That's correct.
All right, so again, I'll ask you, what factual issues have you raised with respect to the other
aspects.
I understand, Your Honor. I apologize for misunderstanding.
No, maybe I wasn't clear.
There is plenty of evidence in the record from which a jury could reasonably infer that there was an entire concerted scheme and that Ms. Weitzman offered substantial assistance to Mr. Oakely in his commission of the entire fraud against Boise, not just with respect to Maspeth, but as the motion court correctly found, hundreds of thousands of dollars worth of other transactions that cannot reasonably, as a matter of law, be parsed apart from Maspeth.
Well, that's what I'm asking. Why not? Why are they connected to her as opposed to the ex-husband?
So if you go back to the very beginning of the record, the events that are significant here begin in 2010, and that's when, as counsel discussed, there was the signing of a healthcare proxy, and the same day, a signing of power of attorney. And a jury could certainly infer that Ms. Weitzman was also present from that. The following year, Ms. Weitzman herself becomes Mr. Boise's secondary healthcare agent, not just a witness, but herself the agent under a VA advance directive as of August 4th, 2011. And that is precisely in the middle of the time period that the expert medical witness said, this is a man who is subject to undue influence. He has a dementia diagnosis. He is in and out of the VA hospital and the Little Neck nursing home. He has declining mental cognition based on...
Yes, but again, how does that connect to 2 years later, money that the ex-husband is alleged to have taken from him? How do you connect her simply from the fact that 2 years before she's an alternate proxy?
No, there's more, Your Honor, and let me give you all that we have so I can try to answer your question clearly. First of all, there is evidence in the record of monies going directly to Ms. Weitzman from Mr. Boise's account, sometimes routed through Mr. Oakely, which shows further concerted conduct, but also straight to her. There's a $398 check paid out on February 4th, 2011, right to her from Mr. Boise's account.
Not connected to Maspeth.
Not connected to Maspeth. And there are charges that were made throughout the fall of 2011 during the period of his incapacitation made to Horace Harding Auto Shop. That is an auto shop on the street where Ms. Weitzman lives. At this point, Mr. Boise was bedridden. He didn't own a car. The inferences that a jury could reasonably draw from those cash disbursements, I think, are clear. And this is a case where the entire constellation of evidence is what's significant. It's not one piece here. It's not one piece there. As the motion court held, the jury could look at all of the facts, the entire flow of money. And I think Maspeth itself, Your Honor, although counsel wants to bifurcate it, it is evidence from which a jury could infer Ms. Weitzman's involvement in the other transactions. There was an oral joint venture scheme beginning in 2010. All of the conversations that Ms. Weitzman ever had with Boise were facilitated by Oakely. He is not, in fact, her ex-husband. They maintain, self-serving, that they are separated conveniently as of 2000.
She uses the word amicable in her affidavit.
She does. They have 2 children together, and there's evidence in the record that the LLC, the sham LLC that Ms. Weitzman formed to protect her assets, as she conceded, shares a P.O. box with Mr. Oakely. Plainly, they are still entwined, regardless of the status of their romantic relationship. And from all of those facts taken together, Your Honor, a jury could certainly infer fraud by Mr. Oakely, fraud by Ms. Weitzman, aiding and abetting by Ms. Weitzman as to the entire scheme. And that's what matters here. So I'm happy to answer any other questions the panel has, but otherwise rest on the brief.
Thank you, counsel. Thank you both.
Thank you.
Century Indemnity v. Office of the New York Attorney General. Please.
Thank you, Your Honor. May it please the court, Avi Sheikh on behalf of Century Indemnity. Your Honors, 2 years ago, the Attorney General's office entered into a settlement with the Brooklyn Diocese of an investigation that had launched 6 years earlier. By its very terms, the settlement was, quote, in lieu of continuing the investigation or commencing a statutory proceeding against the diocese.
You lay that out in your brief very well, counsel. But as you know, they also say they're investigating 6 other dioceses in New York State, and Lesher is the case that you need to get around. It seems like it's an ongoing investigation, counsel.
So two things, Your Honor, right? There's no dispute that there's no ongoing investigation in Brooklyn Diocese. Instead, they make an argument that the investigations are all intertwined, all the investigations of the diocese. There are several problems with that, Your Honor. First of all, in the parallel case involving Ogdensburg, the Attorney General took the opposite position, that they're all separate, not connected. Second of all, Your Honor, in the Buffalo Diocese case, the Attorney General's office has agreed to produce the documents that the diocese provided to the AG's office in response to a subpoena, the same request here. In other words, an exactly parallel case, a settlement in the investigation where they subpoenaed the diocese and the diocese sent documents. The Attorney General's position is sure, 25,000 pages, we'll send it over. Here,
Do you have access to those documents?
do I have access to them? It wasn't my FOIL request, Your Honor.
No, I'm saying, are you saying that that they're not willing to turn those documents over to you?
I have not asked for those documents. That wasn't my case, Your Honor.
So
In the Buffalo
again,
documents.
I mean, you
I'm
could foil them.
unclear.
If somebody else
Yeah.
foiled them, you could foil them.
Right.
The point is, Your Honor, in this case, they're taking the position that the 8 diocese cases are so intertwined that to provide documents from one settled case would hamper the investigation of any other case. However, in Buffalo, which settled, they said, we'll release the documents. It wasn't to us because it wasn't our FOIL request.
Didn't they say we're going to release some of the documents in Buffalo, and there's some subcategory that they did release? Maybe I'm mistaken.
I don't believe so, Your Honor. They have agreed to release the documents that they received from the Buffalo Diocese in response to a subpoena. They may redact some of them first if redactions are necessary. That's not a disputed issue. The third point, if I can make, Your Honor, with respect to the issue of an ongoing investigation, is there is no evidence that there's any active ongoing investigation in the other 6 dioceses. We're sitting here 8 years later. All that the AG's office said in this case about the other investigations, and it's in the Schiffman affirmation, it's paragraph 4, it's I think in the record, Jacob Appendix 236. All he says is those cases remain open. He doesn't give any factual information at all. Remember, the burden is on the AG's office. In Article 78 regarding FOIL, right, their presumption is switched. It's not an arbitrary and capricious standard. The presumption is in terms of release of documents. It's the AG's burden, and they haven't provided anything. In fact, the very same language that they're pointing to here.
What about this Schiffman affidavit, doesn't that get the job done?
No, Your Honor, that's what I'm saying. It doesn't. And in fact, Your Honor, in a case involving the Archdiocese of New York, which is one of the 6 ongoing ones, Schiffman saying, Your Honor, even though in this Brooklyn Diocese case, take my word that they're all open, that the Archdiocese of New York investigation is open. In fact, Judge Connolly, who had that case in Albany Supreme Court, took the same Schiffman affirmation with the same language and issued a ruling saying, no, it's insufficient. Saying it's open is insufficient. You must give evidence. You must say what has happened, what investigative steps has occurred, what steps are you planning to take, and that comes directly from the cases.
Mr. Schick, wouldn't that somehow telegraph their whole investigation process to do well, we have investigators doing ABC and meeting XYZ. That pretty much
absolutely not.
You're asking them to do that.
Absolutely not, and the cases are very clear. But all they have to say is someone with personal knowledge say, I have a meeting set up with a witness. I interviewed 2 witnesses. I made a demand of the diocese. There are a number of factual things you could say that give away nothing other than the fact that something is happening. It's 8 years later. In fact, Your Honor, as we know, in the Jewish press case, right, this court was very clear that just a conclusory affirmation, that case wasn't involving the Attorney General's office, but it was involving the New York City Department of Investigation. And this court, it's a 2021 case, and this court said, quote, even if an investigation or ensuing judicial proceeding were ongoing, we would reject respondents' broad arguments for withholding all of the responsive records, which, if accepted, would amount to a blanket exemption and would seemingly apply to virtually all records of any investigation conducted by respondents. Again here, Your Honor, we have not received...
So let me just ask you this, counsel. You're saying that Schiffman affidavit doesn't meet this test. An agency does not need to make any specific evidentiary showing that disclosure of records would pose any unique or unusual danger of interference to invoke the exception, but must articulate a basis for claiming the exemption by identifying the generic kinds of documents for which the exemption is claimed. That is Abdul Rashid. I can't believe that that Schiffman affidavit didn't meet at least that standard.
I'm glad you raised it, Your Honor, and I appreciate the opportunity to address it. Two things. First of all, the law enforcement exemption is a two-part test. Number one, you have to prove by evidence that the investigation is active and ongoing. Number two, you have to prove with evidence that the release of documents, all the documents are withholding, and here it's a blanket exemption, we got none, would interfere with the exemption. Abdul Rashid, Your Honor, was a criminal case. It was a criminal case that was ongoing, and they asked by FOIL for witness summaries, for crime statements. And sure, in that instance, one doesn't have to say, let me detail each crime summary.
Counsel, Abdul Rashid was conjoined with a civil case too, so I don't know if that's a very strong argument.
I think it is, Your Honor. If one looks at a series of cases, they're all in cases in which you have to explain, if the category of document is self-evident, why it would somehow interfere. There's a case about M187,
Counsel,
which are forms.
But
Your
hear about
Honor,
it on, save it for rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, and may it please this court. Anthony Radawatso on behalf of the Attorney General. This case falls within the heartland of the law enforcement exemption. The Attorney General.
Let me ask you: is counsel correct that that all you've said is that they're open, that you are not actively pursuing these investigations?
No, Your Honor. We provided in this case, both in addition to the FOIL response itself, 2 sworn affirmations from individuals with personal knowledge of both the records at issue and the open investigations, that these investigations are active, open, they're in fact-gathering stages. It also provided an explanation for the differing timelines of those investigations. That record support was also supported by a recent press release from the Attorney General herself confirming that these investigations were open. I'll add, this is a massive statewide investigation of the Roman Catholic Church that involves 8 dioceses and thousands of victims of child sexual abuse.
Is there any dispute? Is there any reason why not to give the documents that you've given already in response to a subpoena?
You're referring to the Buffalo
Yeah,
investigation, Your Honor.
yeah.
So that was a very different circumstance. In that case, the FOIL request in that case was much narrower. It involved the clergy personnel files in that case. They were produced in heavily redacted form.
Did they ask for those files here?
They did not, no. They requested files specifically related to the Brooklyn matter. The Brooklyn matter itself is not, in fact, closed. That matter, there's a conditional assurance of discontinuance in that case, but it requires substantial ongoing cooperation.
I don't know that would exempt you.
Regardless of whether this court agrees with that or not, there is no doubt here that they would impact the ongoing 6 other investigations in this case, including the Archdiocese of New York, which is right next to the Brooklyn diocese. They're overseen by the same archbishop. I'll also add, again, critically, that Buffalo matter was conclusively over. The OEG had actually sued the Diocese of Buffalo in that case and entered into a settlement agreement. There was no possibility of further enforcement action in that case. I want to briefly address petitioner's claim about the standard in this case. This court has repeatedly held, the Court of Appeals has repeatedly held in the Lesher, Medeiros, and Abdur Rashid cases that the exemption applies not only where there is a risk of interference with the case for which the records were originally compiled, but also where there is a disclosure that would disrupt another related investigation. That construction is consistent with the statute itself, which refers to interference with investigations and proceedings in the plural voice. Petitioner is also wrong that OAG again failed to provide adequate support for its reference to reliance on the law enforcement exemption.
Even we've said that standard's admittedly very low.
Correct. And I'll also just add on this point, petitioner points to nothing in the record to suggest that the investigations are inactive. These are, again, very high-profile matters for our office. They have implications for the liability of the diocese, as petitioner is well aware, and their bankruptcy proceedings. It is simply implausible that these matters were secretly resolved with no media coverage or no press release from any of the parties here. I'll briefly address, if your honors would like, the alternative bases for affirming this case. Petitioner does not meaningfully dispute that the bulk of the disclosures here fall under the Section 50 exemption for records that tend to identify victims of sexual abuse. That's because petitioners' requests are specifically aimed at material pertaining to allegations of sexual abuse. The Section 50B exemption is very protective to the extent petitioner claims that we should have produced those in redacted form. It is well established in the Court of Appeals that a court cannot compel such disclosures. Similarly, with respect to the requests for OAG's internal communications, notes, analyses, drafts, and other work product prepared in the course of the investigation, by definition, these materials are exempt from disclosure under both the work product exemptions and the exemptions for interagency materials. And finally, petitioners' requests for the work product and evidence used to reach certain broad conclusions set out in that assurance of discontinuance were not adequately described. It's well established by this court that OAG did not have to do a record-by-record review for the responsiveness to each request like this. If there are no further questions, I would ask that this court affirm. Thank you.
Thank you, counsel.
If I may, 3 brief points. First, Your Honor asked my friend from the state whether we had asked for the same documents, clergy records. And the state answered, truthfully, but not so much, we didn't request them. What he meant to say is we didn't request the Buffalo records that he released. We surely requested the same category of documents from the Brooklyn Diocese as was released in Buffalo. We've gotten nothing, not a single piece of paper. They haven't even reviewed, they've never said that they've reviewed or gathered the documents. They've issued a blanket denial. So yes, Your Honor,
if they said in the Buffalo production that it was clergy personnel records, right?
Yes.
You asked for the same thing for the Brooklyn Diocese and did not get them?
Yes.
Okay.
Yes, Your Honor. That's the first point I want to make. The second point I want to make is this notion that we're suggesting that the investigations were secretly resolved. Of course, that's not what we're saying. What we're saying, I worked in that office, cases don't get closed. They just stop. They get abandoned. It's been 8 years. They have the burden of demonstrating something. You read the cases, DeLuca, Lovey, Judicial Watch, Jewish Press, consistently. They just have to give some
They've
fact.
said, they have an affidavit from someone in the office saying they're open, they're being actively litigated. And here, yeah, I'm looking at it right now. I mean, I could read it into the record if you like, but I'm looking at an affidavit, one Stephen Schiffman, that these are being actively litigated, and here's the crossover of the documents.
There's, again, I don't want to belabor the point that what the courts require somebody to say is not just that's been litigated.
No, I don't think that's what the Court of Appeals has said more than once in Lesher and in Abdul Rashid.
Those
it's
cases,
an admittedly low burden, right? And
those cases weren't talking about whether it was open. But if I can make one final point, Your Honor, they've asserted a blanket exemption here. I'd like to direct the court's attention to the assurance of discontinuance document itself, which is the settlement agreement. It's in the record, and specifically at page 136 of the record of the Joint Appendix, paragraph 125. It's at the very end of the agreement. And that's where the Attorney General's office, in settling that case, laid out what's going to happen if there's a FOIL request. And you know what it didn't say? It didn't say that they're exempt. Instead, it said that the diocese does not give up its right to say those documents should be confidential. It explicitly anticipates that there will be FOIL requests and that they're not blanket exempt, even though now they're taking the position that when they wrote this and years later, there's a blanket exemption. It preserves for the diocese the right to claim that they shouldn't be produced. The diocese, it says specifically they have to notify the diocese.
That necessarily connotes that they're giving up their right to exert the law enforcement?
No, Your Honor. What I'm saying is it certainly doesn't anticipate that they're all blanket exempt in any event. The diocese has not shown up. The diocese, it says in this paragraph, the state has to give the diocese notice if there is a FOIL request, and the diocese has the right to object.
Right.
We're 2 years into this. The diocese has not appeared, has not made an objection. Again, nowhere in the affidavits that Your Honors have before you does it even say that the state has reviewed and gathered the records that they're opining about. We think that this case should be reversed, but at a minimum, it should be vacated. Let the lower court, do an in-camera review of what documents. Let the lower court say, when was the last?
Thank you. Thank you both. People v. David Shur. Please.
Thank you. Good afternoon. May it please the court. Paul Anderson for the people. In the light most favorable to the people, there was ample evidence, sufficient evidence, that Mr. Shur attempted to traffic AJ after AJ was rescued in November 2019. I'm sorry, Your Honor, I thought you were going to ask. No. Okay. So here we had the Facebook messages, which indicated his intent to romance her to come back to the Bronx. We have also in the Facebook messages screenshots between him and a John asking for candy, which ample evidence showing when she was being trafficked in the Bronx prior to this.
So notwithstanding an emotional component to those messages by this Romeo,
yes,
it's a fair statement that there was money involved. There was this constant beseeching her to come back.
Yes.
He wanted bread or money, or he wanted her to engage in prostitution for him.
Yes, and she responded saying, I want to come back on the street and make money for my daddy.
And based on that evidence, in a light most reasonably favored to the people, the jury found him guilty of that, correct?
Yes, Your Honor. In fact, the jury had to give a much higher burden in that beyond a reasonable doubt here. And the jury did find them guilty beyond a reasonable doubt. And yet in the face, and also the prior conduct, which was when she was rescued on the street by the undercover in the midst of a proposed act of prostitution. And then after, immediately, we have all this evidence of Mr. Shur trying to lure her back to continue that enterprise. So we have the existence.
Do the messages show that that he came dangerously close to accomplishing that end?
Well, I think we look at, yes, Your Honor, and I think we look at what that end is here. It's not just advancing an act of prostitution. It's advancing an act or facilitating an act or enterprise of prostitution. And so when we have here a pre-existing enterprise of prostitution, and including him saying during the same conduct, he is getting, or the same time frame, and when he's messaging her in January, then she's not responding. He then tries to manipulate her some more and attaches a screenshot from a customer of hers asking for candy, the only connection that
And that was a buyer of her sexual favors, right?
That's
it has nothing to do with him wanting her back. He's saying, look who wants you. This person, come back because this person wants you, right?
Yes, Your
Not
Honor.
the defendant, not I'm in love with you. This sex buyer wants you, right?
Well, I think that's the facilitation. That's his efforts to try to lure her back. Come back, let's get married, and continue our life that was interrupted and you leaving. And so having...
And she is saying, I want to come back and make you money, right?
Yes, Your Honor. And so defendant, in the light most favorable to the people, if the facts are, as defendant believes it, which is that she is ready to come back at a moment's notice.
Counsel, she's 16 years old, correct?
Yes, Your Honor. She's 16 years old. I think she turned 17 at March, as counsel pointed out correctly. But yes, and so this is exactly what this statute was meant to encompass. And I know I went on a little bit of a history lesson here, but for over 100 years in this courtroom, this is the exact type of conduct. It's now been more criminalized against children under 18, which is what exactly we have here. It's on all fours with what the legislature intended.
That could be interpreted in two ways, meaning one, that he wants her back because he wants them to get married, and two, so you could continue making money for me as a sex worker. Is conduct that's open to both interpretations sufficient to establish your burden?
Yes, it is. Absolutely. It's the light most favorable to the people and all the reasonable inferences that flow in there. I'd say it's still, even altogether, we would meet the beyond a reasonable doubt burden if...
The jury was free to accept one or the other, reject both, or accept both, right?
Absolutely, Your Honor. The jury was free to do all of it, unlike the judge here, who had to accept it in the light most favorable to the people, but did not apply that burden, for lack of, I guess, a better understanding. So if Your Honor have no questions, I'll just wait for rebuttal, and I'll ask that you reverse, Your Honors, and reinstate the violent felonies here.
Thank you, counsel.
Good afternoon, Rachel Lindy from the Office of the Appellate Defender on behalf of Respondent David Shur. The trial order of dismissal should be affirmed. After due consideration, the court below determined that the minimal trial evidence was legally insufficient to establish that Mr. Shur came dangerously close to either knowingly or intentionally advancing prostitution between December 3rd, 2020 and April 17th, 2021. Just to quickly remind the court of the legal sufficiency standard, it does require that a rational fact finder find that all elements have been proven beyond a reasonable doubt. The prosecution was not relieved of its burden here, and the minimal evidence failed to reach that burden.
Why aren't these messages minimal evidence of him coming dangerously close to achieving the end that he was already doing?
They do not come dangerously close because the messages, while indicating some romance, there's nothing in the messages whatsoever that is conduct facilitating an act or honor prize of prostitution.
How about the text message? Here's your sex, here's the guy who's been buying sex from you, asking for candy. That seems to me straightforward.
So the context of that screenshot is very important, and in that screenshot itself, he says no in response to the question. They ask candy available, and he says no. He sends the screenshot, and
Why
then
would
the
he
complainant.
send it to her? I mean, let me just say that. Isn't it a jury fair for a jury to infer that the reason why he's sending that to her is to convince her to come back and sell her services to this client who's been asking for her? Is that not a fair?
Well, that interpretation would be belied by the context in which it was sent. After that screenshot was sent, Mr. Shur refuses to answer the complainant's multiple calls. He says to her, "I really don't want to talk or see a face."
Isn't that equally consistent with manipulating her?
Without anything else in the record that's
I'm just
conduct.
saying, can't the jury make that determination? Is that an unreasonable interpretation for a jury to make? That one, he's manipulating her, and two, he's telling her, look, this guy who you've been servicing wants your services back. Why would that be an unreasonable inference to draw?
Because then in response, if that were a reasonable inference in response, he would then take further action to make that happen. Instead, he's ignoring his.
Well, that's why he
calls.
wasn't charged with actual prostitution, right? He was charged with attempted.
Except that in response then, because he's ignoring, he's saying he doesn't want to speak to her. That's not coming dangerously close to facilitating an act or honor prize of prostitution.
Only if you take that as true, right? That's only if you take that statement as true as opposed to manipulation to get her back.
Except that there's nothing else that's in these communications in which he's getting her back at any point for the purpose of further.
What about the other messages where where she says that she's unable to come back, and he says to her, if you really wanted to return, that he would get her a ticket, and then he tried to trust her.
And then nothing happened.
What about when he says you're supposed to be out there making daddy's money?
So the complainant said that the Court of Appeals has been clear that the mindset and actions of a given complainant do not meet the standard for attempt for coming dangerously close to underlying conduct.
And then his response was, yeah, you're supposed to be out there making my effing money.
And then he says in response, what is not just that, it's more than that, you're supposed to
Right,
be
so
my
it could be
arms
a dual
loving me.
purpose. So in that response, he's saying, it's not only that I want you out there making my effing money, I want to marry you. And the jury had a right to credit both of that, reject both of it, or do what it did.
Except that there's no conduct here that is, right, the conduct for promoting prostitution would be
Out there making money.
solicitation, would be...
You said solicitation?
Yes, and
that's not a part of soliciting her to come back and...
his responding and saying, I miss you, I want you in my arms, that's not solicitation, is particularly when they never see...
No, how about, and you're supposed to be making daddy's money?
So she, again, is the one initially saying
And he
that,
says, yeah, you are, right?
and then he diverts and says, but it's...
So you don't think that the jury could infer that statement as him saying to her, yes, you should be selling your sexual services for me?
Not without
agreeing with that?
Not again without conduct that's coming dangerously close. I would just quickly note that While the prosecution put forward this theory, they rely on no case support whatsoever to demonstrate that this is conduct coming dangerously close. They do not engage with the attempt standard, and the court below was proper in dismissing those charges. So we would ask that you affirm the trial order of dismissal. Thank you.
Thank you, counsel.
So I'm going to pick right up from there in terms of the dangerously close. It isn't dangerously close to a discrete act of prostitution, so there wasn't a burden on the people to show this, that Mr. Shur set up an appointment and she no-showed. And even if there was, we have that here. Candy available? I guess not. No, I'll find maybe someone else is available. So that, then also the only reason to send that to AJ is to indicate this is what you're missing out on. This is why I need you back. And then to go into the idea that we needed psychological evidence to meet our burden, this is not beyond the ken of an average juror of someone playing hot and cold against a teenage girl to play against her emotions. So that is not needed here. What we had the expert testimony of was what the coded language means, what's the culture within the styles or the methodologies of human traffickers, and that's what is here. And that's why altogether, including, again, the completed acts of trafficking, that it was a mistake for the court to grant the motion and to dismiss. So, Your Honors, I ask that you reverse the trial order of dismissal and remand for resentencing on these reinstated charges.
Thank you, counsel. Thank you
Thank
both.
you.
Halpern v. Stephen Van Dam et al. Please.
Good afternoon, Your Honors. May it please the court. Edward Ross, Rosenberg, Calica, Bernie, Liebman, and Ross for the plaintiff appellants Stephen and Jamie Halpern.
Sir, can we agree today that the lot line windows in issue here have not been blocked?
That's correct, Your Honor.
And that there's been absolutely no work being done in the adjoining property as we speak?
That is not exactly correct, in that there's still, in fact, I checked it, a couple of days ago, because one of the things that we point out as a matter of judicial notice and in the record is that there's a pending lawsuit by Pan Asia, the neighbor, who had the prior approvals. Specifically,
We know, counsel, they've been up here. We know that.
Okay, so that is still very much in play. And yes, have my clients lucked out, if you will, that it hasn't happened yet? Yes, but that kind of goes to the heart of the crux of the lower court's error here, which is the lower court essentially said there's no damages for two reasons. One, because they haven't lost the lot windows yet, lot line windows yet, and two, because essentially taking or criticizing plaintiff's expert who opined that there's a 25%.
Mr. Storgen?
No, Mr. Storgen was the bank appraiser.
Oh, I'm sorry.
So this is Mr. Vargas.
Right.
What Mr. Vargas did, and it's in the record, is he assessed a 25% across the board reduction in value due to these, not just the lot line, the fact that the lot line windows, but because they had already been approved by LPC for expansion. That's the equivalent of a zoning approval. Is zoning forever guaranteed as a vested right? No, but it certainly affects the market value, and it affects what not only reasonable buyers, but specific buyers would be willing to pay or buy, knowing that there's going to be that they already have the approval to build up.
Did your expert value the apartment as of the day of the sale?
Okay, so I'm glad you asked, Your Honor.
I just want to know yes or no. It's pretty straightforward.
I will say yes and no. it's not that simple. And I know.
I think it might be, but I just want to know. When
He
you're
said 2021.
2021.
Yes,
Right?
so he did
So there's
2020.
there's no evidence from your expert how much that would have reduced the value at the time of the sale, right?
No, what he said was, in his opinion, which is informed by the Court of Appeals decision, tall trees, which is a judicial principle and matter of policy, that once approvals like these are granted, they're virtually guaranteed in the future unless something intervenes, that he incorporated that as well as his industry knowledge and experience to say when you have these approvals, there's a 25% reduction in value, including dating back to the date of the sale.
Then why not value the property as the date of the sale?
I can't answer why he didn't.
Exactly, right? So
Because
so
it's
we
not-
so there's no basis for, except him saying that, there's no value. He didn't value the property at the time of the sale.
Well, I have several answers to that. The first thing is the date of the sale is not the only relevant date here. Even if damages were strictly rose or fall on the basis of a valuation, which they don't, and I will get to that. But even if you accept that premise, what Mr. Vargas said is that, based on his industry knowledge and experience and the tall trees doctrine, there's a 25% essentially discount given these approvals. Now, the only two appraisals you have is the date of sale, but again, it's not the only date because they later gut renovated the unit for $750,000. But you have the Sturgeon appraisal for $2.53 million, just happened to be exactly the same as the contract price, which is no surprise because appraisers and Fannie Mae appraisers, they have to take into account the contract price because you assume it's an arm's length transaction and that they had reasonable market information. So you have that, and then you have, which is not an expert appraisal, that's just the bank appraisal, and their expert appraisal valued the unit as of the date of sale at $2.56 million. However, Mr. Vargas, and I urge if there's any consideration to affirmance here, to read Mr. Vargas's rebuttal report, he directly impeaches that $2.5 million appraisal as of the date of the appraisal because what their appraisal did is he did a match pair analysis, which does not hold up based on lot line windows, which didn't have the approvals. And in fact, in some of the match paired sales unit analysis that he had, there was virtually zero chance of them building up. So again, I see my lights up.
You'll have time in rebuttal, counsel.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. Respondents, Dominic Pintavalli on behalf of respondents Heldon Hines and Mark J. Eld, Esquire. As plaintiff said, damages haven't occurred here yet. A valid claim of legal malpractice, as opposed to my clients, must be supported by actual and ascertainable damages that are clearly calculable. All the damages that have been calculated here have been vague, unclear, or speculative.
Counsel, say the plaintiffs, the Halperns, want to sell the apartment. Wouldn't they have to disclose to someone, to a buyer, that, hey, those are lot line windows, they may have to get covered up?
Yes, that would be relevant.
And but doesn't that necessarily cause some diminution in the value of the property?
Well, I'll counter you with this, Your Honor. The Sturgeon appraisal, which was a neutral party, wasn't an expert, they valued it at 2.53. That was considering lot line windows. So that appraisal was actually done not considering windows
sorry.
there.
I didn't mean to cut you off. When you said considering, my understanding of Mr. Sturgeon's appraisal, that he considered or gave that number, assuming that there were no windows on the eastern side of the building, which would mean no lot line windows, correct?
That's correct.
So that's the equivalent as if they were blocked up.
Correct.
Right. No windows at all, essentially. is
Correct.
how
That's what the appraisal was
So
based
wait,
on.
are you agreeing that you have your clients had the obligation to go out and look? I think that was what Justice Moulton was just asking you. You're saying that
you have an obligation to go out and make that disclosure?
I would agree with that, Your Honor.
The sellers have the obligation to tell the buyers, or is it the buyer, isn't it? Everybody does their own?
Right, so in this specific case, there were a lot of intervening acts here. The seller's attorneys actually knew of the possibility of the neighboring building upwards before we even were involved in the transaction. In addition to that, the brokers had knowledge of it, and the appraisal report that was provided to appellants, as Your Honor had mentioned, included, the valuation that there were no windows there. So when you go through the three appraisals, that being Sturgeon,
I'm just curious, you're saying that you have an obligation to make that disclosure? Isn't it buyer be, right, but I'm saying, right. Isn't it everybody, I mean, aren't real estate transactions, I buy them as is, it's up to you to find out what there is to find out? Or are you not agreeing with that? Are you saying you do have an obligation?
I do agree to an extent. The only thing I don't agree with was that in this specific case, even if that wasn't disclosed or was disclosed, there are several parties before that that had that information that was available to the appellants that should have been disclosed before we were even involved. So that's where that intervening act severs
It doesn't matter, you're saying whether there is or isn't.
I'm saying that it severs the proximate cause of the damages.
Counsel, you were never, H&H was never asked to research this question by the plaintiffs, right?
That's correct. And also the plaintiffs testified to the fact that they looked out the windows, they saw the building below it, they asked about it when they had first looked at the apartment. Whether they knew it was called a lot line window or the definition of a lot line window, they certainly knew the windows were there and that there was a neighboring building that could potentially build upward.
Thank you, Counsel.
Good afternoon, Your Honors. May it please the Court, Robert Angelillo for the Elliman respondents, who includes Maggie Marshall. And I would just pick up quickly where counsel left off. There was really no dispute here that everyone knew about the existence of the lot line windows. It's in the offering plan. It's in the proprietary lease. As counsel just mentioned, it was known at a meeting. But I think that
I'm sorry, what was in the offering plan?
the references to lot line windows.
That there are lot line
Yes,
windows.
in the
that there was a-
proprietary lease as well.
Right, okay,
So they knew. The concept that they didn't know about the lot line windows is not really in dispute anymore. But I think it's important to go back to Sturgeon, and counsel touched on it, but Sturgeon made it clear, $2.53 million, the exact price they paid, and he testified specifically, that's as if there were no windows on that side. So what they're actually saying is, we like a windfall because we've gotten 9 years of 11 windows, when we really, paid for 3 windows. But so now we're prejudiced that when we try and sell this, someone might find out.
There is the reno question. They did the renovation so that 3 of the windows, all 3 eastern windows are either part of the boys' room or the kitchen. So that they did something in reliance on the fact that those windows would stay open.
And they have, and they're still there. I've been in the apartment. They're there. And it's never changed. This is getting outside the record, but I mean, the children will be leaving for college, presumably. I mean, they've had the benefit of what they bargained for all of the years they've been there.
Is there any evidence that the value of the property, other than someone valuing it several years later and saying, and by the way, it's 25% for every year, or it was unclear to me what it was, every year or a year or whatever. Is there any evidence in the record that the sale price would have been different?
You mean if it builds up?
No. Just with the lot line windows.
I think with the lot line, if those were not lot line windows, if they were regular windows, I think it would have cost a lot more.
Right.
So that's why I say this is a.
But I'm just saying that there's no damages. There's no evidence in the record that it would have been less.
Right. There's no evidence of any damage here, and I think the Sturgeon report is particularly important because counsel will say over and over, battle of the experts, battle of the experts, battle of the experts. It's not a battle of the experts. He was a fact witness. He at the time of the transaction came in and said, this is what it's worth at his deposition. So what about those windows? Oh no, I discount those. They're not there as far as I'm concerned.
And there's no fact witness to dispute that.
Absolutely not. And I think it's important just the judge granted Elliman's motion on that specific basis as apart from the others. Now, I would point out, I think the no damages issue works to the benefit of all of the defendants equally. But that was a separate determination she made with respect to our motion, and it's not even raised in the brief. You don't see Sturgeon's name in the moving brief at all. You see a little in the reply, oh, he had the contract price. But they don't even address that. So in my view, they abandon any argument about the Elliman and the Sturgeon position in any event, and certainly raising it in reply is not sufficient. If I may very quickly, they raised two claims essentially against Elliman, misrepresentation and then negligence. With respect to misrepresentation, an alternate basis for affirmance, not raised by the court, but there's a contract here where the plaintiff said, we're not relying on anything said to us by anyone, including any broker. And now they come and bring a case and say, we're relied on what the broker said.
I was asking your colleague about that. Why is there a burden if there's a contract that says that no one's relying?
No reliance. And the cases are clear that no reliance means no reliance. And then with respect to
Go ahead.
negligence, the issue here is not whether or not there was a breach of fiduciary duty, which is strictly a legal determination that their expert purported to make. But the bottom line is there's no duty to investigate. For a broker to go out and investigate the next door neighbor's property, what, they have to investigate the properties down the street to see? There's no duty there to do that, and no one has ever shown any case or fact that there is. So for all of those reasons, we think that this order should be affirmed. Thank you.
Thank you, counsel.
Your Honors, the Sturgeon number, which was, their own expert valued the apartment as a date of sale at $2.5 million by only giving a 1% discount for them being generic lot lines. And our expert says, no, it's a 25% reduction on any date evaluation. And there's, between the gut renovation, there are multiple days here. These are tribal issues for the jury. Again, that's why I implored to read Mr. Vargas' rebuttal opinion. On their own expert appraisal opinion, that makes the sale price lower. But this is not just an appraisal case. We're not dealing with a capital asset or securities. We're dealing with their personal home. And one of the defendants' counsel said it perfectly when he said, an apartment is not just a capital asset. So if, for example, they had bought this apartment and got a good deal, what they thought they were buying, which they were, and it's in the record, it's in our brief, they were representations by the Elliman defendants. Page, you can see it on page 4915 in the record of the emails internally with the Elliman people talking about what can we tell buyers, because they're, all buyers are going to be looking at this and going to be asking about these windows. Can we ever tell them that it cannot, in bold, all capital letters, be built? He said, yes, we could tell them with assurance. The Halperns, both affidavits, swore to the fact that they received those assurances and
They
that
sign
they
a
would not have
document that said that they wouldn't rely on anything like that?
Your Honor, that first of all, that only goes to the
I'm just
fraud
asking
and-
whether
that
they
go-
did.
Only goes to the fraud and misrepresentation
Right.
claims. And as to those, we did brief them. The
Okay, but so
disclaimer is
the-
not
so then-
specific enough. And okay, but again, this is not just an appraisal issue. They bought this apartment based on, they hired professionals. This court has said in Johnson case, you satisfy your due diligence by retaining professionals. They had a whole team of professionals, and that's why you have 8 different experts here about professional and breach of professional duties. On the issue of damages, this case has so many issues of fact with regard to damages, what date to consider, whether or not it's a pure dollars and cents of market value as compared to when my clients actually thought they were buying. They flat out say they would not have bought this. And in response, the respondents cite a Ma case from this court and said, well, that's speculative whether or not they would have bought an apartment. In the Ma case, the speculation was over the sponsor's future breach of contract, not the present fact, not only undisclosed, but misrepresented and not evaluated or counseled by the attorney who they hired, that they were buying it with permanent windows. Now, they would not have bought this apartment, whatever it would appraise that. If it applied to farmland, a family farmland, if you bought I don't want to be hyperbolic about it. Turns out there's oil on there. You know what? That's a windfall that there's oil, but if they thought they were buying a farmland to use as undisturbed farmland, and that's not what they got. And they said, you know what? We wouldn't have bought it. I don't care that there was oil there. Our clients are emphatically
you make that
testified
point.
that they wouldn't have bought this apartment.
Thank you, counsel. You do make that point well in your brief. Thank you. Thank you all.